look at the file.
No, Lordship, the file has been misplaced due to reshifting of my senior.
We'll do it when the matter reaches, not at the mention time. Yes.
Lordship, with the consent of other side, Lordship, I beg to mention item 17, Lordship.
17.
17, Lordship. It is 23 meter, Lordship. I need 2 weeks time, Lordship. Finally.
Someone for the,
P month was
or you
inform.
informed? Okay. Wilderness Standing Council, Irrigation Department has sought for an accommodation to file the affidavit in opposition
Or instruction, Lordship.
or instruction. Full stop. The learned counsel for the petitioner does not object. Let the matter be listed after 2 weeks.
Lordship.
The date to be fixed by the registry, by which time the department shall ensure applying the instructions. Yes.
May I please, Your Lordship, with due consent of others, I beg to mention item 15,
15 years.
After a week, Your Lordship, my friend is there. My friend.
I'm for the respond. Item 6.
At the joint request of the learned counsel for the parties, list this matter after a week.
After a week.
May I pray for a date, my lord?
It has not come up as a fixed matter. It has not come up by order. It has been listed by luck. So we will wait for luck for 1 more week. Because the vacations are coming up, we are not pressurizing the registry.
Okay.
May it please, Lordship,
Yes.
with the consent of the other side, I beg to mention item number 39.
39.
In item 39, I have been newly engaged, my lord. Today I am appearing, my lord, and moreover, the railways filed an affidavit. We need to file a rejoinder to that, my lord.
Okay.
So after 2 weeks, my lord,
Mr. M. Biswas, learned counsel appearing for the petitioner has submitted that he has been newly engaged in the matter and would require some accommodation to acquaint himself with the matter. Full stop.
as well
Yeah.
as filing a counter to their
As well as to file counter if required to their affidavit in opposition filed by the railways. Full stop. Prayer not being opposed by the standing council for the railways, comma, list this matter after
2 weeks.
2 weeks on a date to be fixed by the registry.
There is an interim order.
The interim order shall continue in the meantime.
I'm deeply obliged.
May I please, Your Lordship, I beg to mention item number 13 on the behalf of Mr.
13.
P. Sharma. Mr. P. Sharma, AFDC.
On behalf of
P. Sharma, AFDC.
the petitioner, you have informed.
Unable to contact.
If the matter reach, they'll be here.
Yes,
We'll give you
Lordship.
that. Yes.
May I please, Your Lordship? Your Lordship, with the consent of the other side, I beg to mention item number 14 of today's list.
1-4.
Yes, Your Lordship.
Yes.
And in this matter, Your Lordship, we are filing one additional affidavit to bring on record certain further development in the matter.
Hmm.
So, Your Lordship, for that, we may allow 2 weeks time in this.
You have informed the council
Yes,
for the other
yes,
side?
I have taken the consent.
The council for the petitioner has submitted that he would be required to file an additional affidavit to bring on record certain developments which have taken place after the filing of the writ petition. Full stop. The request not being objected to by the London Council appearing for the respondents, comma. Let this matter be listed after
2 weeks, sir.
2 weeks on a date to be fixed by the registry.
Hello.
May it please, Your Lordship,
Yes.
in respect of item number 28,
28.
Lordship, the respondent number 2 has filed an affidavit in opposition.
Hmm.
Today, my lord, we have received the copy.
Hmm.
My lord, we'll require some time to go through it. If necessary, we'll file a reply to it also, Lordship.
The London Council for the petitioner has submitted that they have received a copy of the affidavit in opposition being filed by the respondent number 2. And he would require some time to go through it and formulate his reply if so required. Full stop. This is matter after 2 weeks
2 weeks, Lordship.
on a date to be fixed by the registry. Ms. So-and-so appears for the respondent number 2.
Deeply obliged.
Yes.
Lordship, in item 51, we need certain instructions from the petitioner's lordship. So kindly take it up after 2 weeks, Lordship.
Mr. S. The London Council appearing for the petitioner has submitted that certain instructions are required from the petitioner. Certain further instructions are required from the petitioner. Full stop. Is to be accommodated for
2 weeks, Lordship.
2 weeks. The prayer not being objected to by the Learned Council appearing for the respondents. Is this matter after 2 weeks on a date to be fixed by the registry? Yes.
May I please, Your Lordship? Lordship, I beg to mention for item number 16,
16.
it will be after 2 weeks.
Yes.
We will file an affidavit reply in on respondent number 6.
A prayer has been made on behalf of the petitioner to accommodate for how much time you need?
2 weeks, Lordship.
2 weeks. To allow them to file an affidavit in reply to the affidavit in opposition filed by the respondents. Full stop. Cannot being objected to by the learned counsel for the respondents. This is matter after 2 weeks on a date to be fixed by the registry.
Yes, Your Lordship. Lordship, I beg to mention item number 18.
1-8.
Yes, Lordship. I pray for adjournment, Lordship, the consent of the other party.
Huh?
I pray for adjournment, Lordship. Consent has already been taken.
You are appearing for whom, madam?
For the petitioner, Lordship.
Petitioner. A prayer for adjournment of this case for how much time?
Lordship, 2 weeks.
2 weeks has been made on behalf of the petitioners, which prayer is not objected to by the learned counsel appearing for the respondents. Full stop. Registry to list this matter after 2 weeks on a date to be fixed. Well, 17 নে 18 যে এখন হেৰি দিছিলে সেইটো মেনশন হল নেকি? 18 হৈ গল ন? Yes, madam.
May I please, Your Lordship, the instant matter has become the infrastructure. The respondent have made payment to the petitioner. Therefore, I have received the instruction to withdraw the contempt proceedings.
Your name is
Uh,
P. Mishra.
P.
Your name?
As does on
As-
behalf of P. Mishra.
Mr. Esdas appearing on behalf of P. Mishra, learned counsel appearing for the petition has submitted that the order of which violation had been complained of has been complied with by the respondents. Full stop. Therefore, no further adjudication is required in this present contempt petition. Mr. M. Bhagawati appears for the respondent number 1.
I'm for 2 and 3.
And since appears for respondent number 2 and 3, full stop. Since the order has been complied, since the order of this court has been complied with, full stop, this contempt case is closed on compliance.
Order is complete.
May I please, Your Lordship? Qualification, Lordship, implement for new incumbent, Lordship, respondent opposite party number 2, Lordship. He is the new incumbent, Lordship.
Yes, sir. What do you say? He has been served a copy.
Lordship. So
He has
copy is
been
not,
served a copy, if I'm not wrong, on 14/8.
Lordship, actually, we were engaged later, by the later part, so we don't have it with us, but
You were engaged by the earlier contemner.
no, yes, I mean, we've been engaged later, your Lordship, in this matter.
For whom?
On behalf of Mr. A.K. Bhuiyan, Lordship. For
Who
BTC,
does he appear for?
BTC, Lordship.
PT is
Anurag
not a party in this
Anurag Goel,
petition,
Anurag Goel.
but Mr. Swansel counsel appearing for the applicant.
Applicant, Lordship.
It has been stated that there has been a change in the holder of the office of the principal secretary, Borland Territorial Council, Bodofa Nagar, Pokrajhar BTA. You will find it at page number 2, huh? Make it page number 3. Serial number 2, principal secretary selling. Full stop. The new incumbent in that post had been informed about the orders passed by this court through the communication received by the new incumbent on 14/8/2024.
24.
Date of information to him till now 1 year passed. Can withdraw contempt.
So what happened, they have after communicated, they did not communicate with me, Lordship. That is why some delay is there, Lordship. I have
Their
filed
peril.
after a very long time, Lordship. Yes.
That is
Admitted,
their
Lordship.
peril.
Yes, sir.
14/8/2024, full stop. The learned counsel for the applicant submits that the orders passed by this court has not yet been implemented, full stop. So and so appears, who appears for the,
Mr. AK Bhuya, Mr. M. K. Das.
who appears on, Mr. M. K. Das, who appears on behalf of Mr. A. K. Bhuya, who represents the contender number 1, submits that the contender number 1 is no longer holding the office. Full stop. In view of the above, this implement application is allowed. Stop. The opposite party number 2, namely, you will take from page 3, serial number 2, huh? So and so is included as a respondent in contempt case number 563 of 2022. Huh? Full stop. Interlocutory application accordingly disposed of. In the main contempt case, you write by an order passed today in IA number so and so. The so and so has been directed to be implemented as the respondent number 2 in this contempt petition. Full stop. The petitioner shall file an amended cause title before the registry within a period of 3 working days from today. Full stop. Steps on the respondent number, newly implemented respondent number 2 by speed post be taken within a period of 1 week thereafter. Full stop. List this matter again after 6 weeks along with service report. Stop. You don't want to file any affidavit on behalf of the contender number 1. It is during your period that the
No, Lord. Previous contempt.
so if he did not do anything to comply with the orders, still have him in our
Unless you may give us.
Huh?
that.
Mr.
Then-
M. K. Das, learned counsel appearing for Mr. A. K. Bhuya, who represents the contender number 1. Respondent number 1 shall have his instructions whether he would be filing a response to the contempt case since the period during which the respondent number 1 had held office is including the period where the order was not complied with.
Similar order, similar.
Huh?
Similar.
Similar. Okay, similar, you change the contempt case number. And in the main contempt case also. Huh? Same.
No, that's good.
May please, your lordship.
Just a minute. Yes,
Council, Mr. B. Deka, he is out of station to be granted a Kohima Mala outline bench. So kindly pass over the matter for two. He is appearing for respondent number 7 and 8.
A date may be fixed, man.
huh?
2016 matter, a date may be fixed, man.
The matter was required to be listed in October. You waited for the entire November. What is the hurry now? What is the matter regarding?
My lord, it is a, my lord, compensation matter. My
Huh?
husband of the petitioners, my lord.
Uh-huh.
He was, he picked up by the army personnel, and from that day, there is no clue about him. My- And a matter, my lord, incident took place in 2001.
You have approached the court in 2016.
16, my lord. No, my lord.
It's a single bench matter. Huh? You're asking only for compensation.
Compensation, my lord.
Okay. The matter relates to
I'm not filing by the party.
sanction of appropriate compensation oblique ex gratia amount in favor of the petitioners who claim to be the kith and kin of Probit Nursery, who is presumed to have been killed by unknown extremists or have suffered demise in the hands of the state authorities while in service. Stop. The earlier order dated 3/9/2025 already records that the pleadings are complete, full stop. Today, when the matter is called upon, prayer has been made on behalf of Mr.
B. Deka.
B. Deka that he is attending matters in the outlying bench and is not available today. Accordingly, list this matter with next week.
In his one.
The next week for consideration.
Must.
Obliged.
What is?
Lordship, this matter resolved already through the mediation, Lordship.
Respondent number 2.
Mediated.
Yes,
So we'll just record that.
yes. On the basis of that, matter may be closed.
They've already received some amount, it
Yes.
appears. 50,000,
Total 4 lakh they have received.
50,000 by this and 3 lakhs by this. 50,000 by this. So we close it?
Yes.
Close.
Anything left?
No.
Decide.
No,
Anything left to decide? No.
this matter will be closed, Lord.
Huh?
Close.
Close the matter. Yes, heard Ms. So-and-so Learned Counsel appearing for the petitioner, also heard Mr. A. Bhattacharya Learned Counsel appearing for the
Respondent number 1.
respondent number 1 and
I am for respondent number 2, Lordship.
respondent number appearing for 2. Member Secretary, Assam State Legal Service Authority, you will appear? Yes, Mr. So-and-so, I am appearing for the respondent number 3. By the order dated 27/8/2025, the matter was referred to High Court mediation. Full stop. It appears from records that the mediation took place and the parties have settled their grievances. Full stop. By the report dated 24/9/2025, the mediator, learned mediator has reported that the petitioner and the opposite party have settled all issues between them regarding the present writ petition and full stop. Therefore, this court is of the considered view that nothing remains to be adjudicated upon. Full stop. This writ petition is closed on mediation and settlement by the parties within themselves.
Obligation.
Yes, sir.
My lord, mediations, my lord, this ADC does not turn around, my lord. My petitioner, 85 years old, twice he appeared, but he, 2 occasions also he was absent. The matter is, my lord, de-reclusion proposal is given by the government. It is to be executed by Deputy Commissioner Dhubri. That was not done. That is
What proposal is given?
My lord, this land was acquired 71. After that 98, there is a proposal from the government secretary. So de-requisition, because this is not required for embankment, there's a high hilly area. So that was not done. Ultimately, my lord, the repetition filed in 20, and your lordship has think it fit to mediation. So mediation, they have not turned around. So that is why the report is there, my lord. But
Mediation,
mediation, because ADC from now, nobody turned around from there of the respondent side.
Yes, what did you, what is your stand in the matter, sir?
My lord, it says, my lord, DAG number 1370 was deleted from the land record and a new DAG has been added and it is 1383 and it is shown as government first land measuring 1 biga 2 quota 6 lesser.
Page 18, kindly see, my lord.
It is neither here nor there. We just want to know that if his land had been acquired, and we just want to know that if he has been paid the compensation.
Yes, madam.
If the compensation has not been paid, whether it has been reacquired, no. What will be the time released?
My lord, it can be done one more mediation, my lord. I will take the initiative. I will inform the Dhubri, ADC Dhubri, my lord.
If the person is not in a position to move, perhaps the commission, anything can be.
Yes, my lord. So
85 years old when he was
85,
Yes, because 16, 70.
Now 67.
That's true, my lord.
One
One chance mediation, everything will.
Put it once again from mediation,
we'll
let me
try
take
it.
some initiative.
I'll take the today itself. I'll write them.
Otherwise, my lord, in similar case, my lord, there is some positive information from ADC, my lord. But this is different writ petition. His brother.
That number should be different. The
That
entire
number,
নাই সেইটো দিছিলে পূৰ্বদিন
Yes, but one bigha lands is between the two brothers. So
Put this before the ADC.
yes,
DC my lord DC my lord.
Deputy Commissioner, yes. This matter was, take it down like this, heard Mr. M.J. Burwal and counsel appearing for the petitioner also heard. So and counsel appearing for the respondent.
Number my lord 2345
As for 2345, Mr. Bhattacharjee for
1.
1. Full stop. This matter was referred to mediation by the order dated 14/7/2025 and the report placed as X reflects that none had appeared for the respondents on the date when the matter was taken up for mediation. Full stop. On the dates, you say none had appeared on the dates on which the matter was taken up for mediation. Full stop. The learned counsel appearing for the respondent number 2, 3, and 4 has submitted that the matter may again be referred to mediation.
No, not my lord. Then let that court pass an order. No, it's not at my request.
Oh, it appears that then you can second. It appears that the state respondents, more specifically the respondent number 2, would be required. Respondent number not 2, 4. 2 or 4?
Deputy Commissioner.
DC my lord.
4. Respondent number 4.
4 my lord.
Is required to attend mediation processes directed by this court. Full stop. No reason has been given as to why he did not appear on the apposite dates. Full stop. Granting one more opportunity to the respondent number 4 to participate in the mediation process under directions of this court. Full stop. Let this matter be placed before the mediator
My lord,
on
after a week, any day, my lord.
Now we have to give a date. You can give us a date.
Yes, 6, 7, 8, my lord, 8
On
November.
the 8th of December 2025. The 8th of December 2025,
1 p.m. man.
1 p.m. Full stop. The respondent number 4 and the petitioner shall appear before the Guwahati High Court Mediation Center, Guwahati on 8/12/2025 at 11 a.m. Full stop.
None. 11 is all right, man. Either him or any authorized representative.
The respondent number 4 may depute a responsible officer with knowledge of the facts of the course to represent him in the mediation process. Full stop. Copy of this order given to Mr. Das to the needful. Place this matter again immediately on the reopening
Yes.
for further consideration and mediation report.
Yes.
For mediation report and further consideration.
Yes.
Obligation.
May I please, your lordship? My senior is in other courtroom. Matter may please pass over for the time being.
Wait, please, my lord. My lord, I am appearing in this matter for Mr. B. Chaudhary, my lord. My lord, today morning we have sent it for hearing this matter, my lord.
Yeah, affidavit in opposition.
Yes, my lord. Within 2 days you can file it.
Mr. appears on behalf of the learned counsel. And counsel appearing on behalf of Mr. B. Chaudhary, Learning Council Finance and Taxation Department has submitted that the affidavit response to the petition has been prepared and can be filed within a period of 3 days. Full stop. Is this matter again after 2 weeks on a date to be fixed by the registry, enabling the respondents to file their response. Full stop. Petitioners would be at liberty to file their reply, if any, to the affidavit of the respondents before the next date fixed. Full stop. Interim orders passed earlier shall continue. Did you understand the order? No. He wants to file an affidavit in opposition. We have given him the time, the interim is continued. Yes. Ah.
Your Lordship, just now I have taken instruction from a senior.
Hmm.
Last occasion, Your Lordship, the learned circle officer Gusaigaon
Hmm.
has filed their affidavit in the position. We have received it. If required, we will file a reply. We will have to go through it as the file is now untraceable quite.
See, a little coaxing and you do your work. Is it not?
Yes, sir.
The submission has had to come.
Simple
Simple adjournment is not going to work. Then
Okay.
It an affidavit in opposition has been filed by the respondent number 4 on 15/11/2025 and the counsel appearing for the petitioner has acknowledged receipt of the same, full stop. He prays for an accommodation of 2 weeks. File the affidavit in reply to the affidavit in opposition filed by the respondent number 4. Full stop. List this matter again immediately on the reopening. Along with the affidavit in reply proposed to be filed by the petitioner. Full stop. Any interim orders? No.
No interim order.
Huh?
No interim order is there.
Interim order,
Lordship, in this matter, we have a communication dated 26/8/25.
26/8/2025. Same.
Whereby it was stated that we had actually contacted the landowners to provide a compensation, but they refused to accept the same. So Lordship, may kindly allow me some time to file an affidavit to bring this on record.
Is it? What if we refuse it?
Lordship,
On the ground, when is your dated, that letter dated?
26th August, Lordship.
26th August.
2025.
এখন তেওঁক দিয়কচোন। We have something which is better than what you have. Look at the date.
Lordship, 15th October, 24.
We are more updated. Yours is of August. This is of?
But Lordship is 24, Lordship.
It's 24. Oh, my mistake. I did not look at the year. What does your instruction say?
Lordship, we had contacted the landowners to provide the compensation.
Then this will contradict that. This says BTC has got nothing to do with it.
This is the latest status report which we have been.
Lordship, if I may state something, Lordship. Now, Lordship, as per the respondent's Lordship, the fact of the matter is this, Lordship. The land was acquired in 1992. Okay, the case was filed in 2020, the dispute and writ petition. And after this period of nearly more than 30 years, Lordship, they are paying a compensation of 3 lakhs for more than 23 bighas of land, Lordship, to all the petitioners. Is it viable, Lordship? If compensation has to be paid, it has to be paid at market value. There are two along with Solatium, Lordship.
That will be reference court, my lord. That will be reference court if he is aggrieved, my lord. And the DC says, my lord, though the original record could not be traced out, compensation has already been paid.
No, Lordship, no compensation.
Balance amount to be paid to them could not ascertain in spite of the receipt of the petition dated 28/6. My affidavit says. So, my lord, let the affidavit from the BTC.
Council appearing for the
respondent number.
BTC authorities has submitted that he has received instructions in the matter and require some time to bring to file the affidavit in response to the writ petition. Let the affidavit come. Prayer is granted. Let the affidavit in response to the writ petition be filed within a period of 2 weeks. From today, advance copies to the counsel for the petitioner. Petitioners may file their response to the affidavit in opposition before the next date of listing. Full stop. List this matter in the 3rd week of January 2026, along with the affidavits filed by the parties. What more? Yes, madam.
Matter pertains to the non-payment of contractual dues, Lordship.
Contractual bills.
Yes, Lordship. Liability statement at page number 16.
Who is supposed to pay the amount?
It will be the water resource department.
Who appears for the water resource department? বাইরে স্ক্রোলটা দিয়ক অলপ পিছত মাতি দিয়ক ওয়াটার রিসোর্স ডিপার্টমেন্টৰ মাতি স্ক্রোলটা দি দিয়ক ওয়াটার রিসোর্সেস ডিপার্টমেন্টৰ এইটো আইটেমত অলপ পিছত মাতি দিয়ক
Your Lordship, my Lord Senior Counsel Ivan Lack, may I please beg to take this matter up for some time?
after some time.
Yes, please.
What is the matter about?
It was Ainul Haq versus the Union of India.
Unfortunately, we did not get to know what is the grievance of Ainul Haq. I asked him what is the matter about. He said it is Ainul Haq versus state.
Yes.
Okay, let your senior come. After some time.
Thank you. God bless.
Thank you. Water resources.
Yes, my lord, I am appearing for the department.
Yes, madam.
Here, my lord, we have received some instruction. Affidavit in fact is ready. So by next week, we can, matter can be taken up.
Mr. Chakraborty Leonard Council appearing for the respondents have submitted that respondent water resource department has submitted that they have received the instructions and would be in a position to file the affidavit in opposition in the next week. Full stop. Yes.
Yes, Lordship, matter may be taken up with WPC number 61.
Just a minute. Allowing the respondents time to file their response. Full stop. Let this matter be listed after 2 weeks on a date to be fixed by the registry, along with the affidavit in opposition proposed to be filed by the respondents. Full stop. Petitioners would be at liberty to respond to the affidavit in opposition filed by the respondents, if any. Full stop. Leonard Council for the petitioner has read that this matter may be listed along with WPC number.
61/2023, 49/2023.
Are they with the same?
Yes, Lordship, same
same
scheme.
okay.
Yes, Lordship. 206/2023.
Registry to verify, registry to all these matters together on the next date of listing.
Right, Lordship.
The matter become infructuous.
Sri UK Goswami Leonard Council appearing for the petitioner has submitted that the matter has become infructuous. Stop. Review of the submissions made, full stop. This writ petition is closed as infructuous.
Earlier, my
Yes. Who appears for the corporation?
Yes, Lordship, on the behalf of P. Sharma,
they're taking time, my lord, time again and again,
Mr.
my
P.
lord.
Sharma is suffering some ailment and not in a position to attend the court, sir. Would you object to that? The record objections on that? I will fix it immediately on, what is this matter about regarding?
Regarding tender, my lord, I was settled, my lord, later on, my settlement was cancelled, my lord.
Okay, your settlement was cancelled.
Yes, my lord.
So now you are not holding anything.
No, my lord, I challenged the,
You challenge the cancellation.
yes, my lord,
Someone-
cancellation and subsequently, my lord, tender, new tender process was called and settlement was with another, my lord, respondent
Mhm.
number 6, my lord, with respondent number 6, settlement was done, my lord. Both settlement and new tender, my lord, I challenge in this writ petition, my lord.
There is one order here saying that you were at liberty to file the, to challenge the new settlement order. Have you done that?
Yes, my lord, in this writ petition, my lord, I challenge.
It has been submitted on behalf of Mr. P. Sharma that to attend the court proceedings today. The matter may be taken up may be taken up after 2 weeks.
Vacation.
Date may be fixed, my lord.
I will fix it in January to yes. Maybe taken up immediately after the vacations. Stop. Learned Counsel for the petitioner has submitted urgency in the matter. Let this matter be lifted on 20th of January 20. সেইটো মই মেথ চাই আছো একে হ'ব মেৰ লগত একে হ'ব নি নহয় কিহৰ লগত একে মেৰ লগত একে 20 January 2026 make your arrangements
Most of that. Maybe.
yes
My lord, in this case, the petition is owning, my lord, a plot of land of 3 bighas under Dag number 523, my lord, of Patta number 36. And under the same Patta, my lord, he is occupying some land under Dag number 487, my lord. So, my lord, a transmission line was drawn on over his land, my lord. So, my lord, he has paid the compensation for the land occupied by him under Dag number 487. But he has not been paid, my lord, any compensation for his land under Dag number 523, my lord.
okay yes madam
I have received one instruction, Your Lord. Already they have received amount, Your Lord, 7,60,000.
for which tag number have they received
487.
Yes, Your Lord.
have you seen the piece of document have you seen that piece of
No,
document
I
she is
have-
holding no
I have not seen
so
that.
let her say first yes
They have received, Your Lordship can go through this and I have one copy with me also.
This who represents the circle officer Boroma Revenue Circle.
Normally, Lordship, we, but in BTC area land matter 6 schedule, they will, Lordship.
Standing Council BTC at a scroll did you? Standing Council BTC at a scroll did. We'll have it after some time. Let the BTC be well. Sorry, sir. Yes. অলপ পিছত মাতো অলপ পিছত লিষ্টখন চেছ হতো Okay. একজন উকিল একজন Yes, you are appearing in 21.
20 and 21.
20 and 21. You have 20 khano diog. Yes. Tell us.
Lordship, matter pertains to the excess of GST amount, Lordship. Lordship, last occasion petitioner was directed to obtain instruction, Lordship.
Petitioner was
the respondent was. And we have implemented Commissioner and taxes as party respondent number 4.
Just a minute. do one thing. We're passing this over for the time being. Go through the last order, go through the office note. Let him do his job.
उसको बोलिए ऐसे ये अच्छी है
Railways, who appears for the railways?
Awaiting instructions, Lordship. This, I'm awaiting instruction, Lordship, because geology and minings are there, Lordship. State government.
Who appears for the geology and mining?
Yes, my lord, I am being.
Directorate of Geology and Mining?
Yes.
Where is the office? Where is their office?
Mining. আমার কামই নাই তো
Kailipara.
Yes, my lord.
And Assam Mineral Development Corporation, Dispur.
Yes, my lord.
At 2 with instructions. If they are not having it from 220, do you have instructions in the?
No, my lord.
No. At 2, either instructions or the officers. 2023 matter.
Yes, my lord.
Yes, we will not take it. If we take time to argue the matter, it is one part. If you take time to file the affidavit, it is one part.
Yes,
If you are awaiting instructions when notice has been issued,
Yes, my lord. The others.
separate chapter, we don't want them, we want
After some time, my lord.
2.
Next week, my lord, kindly.
At 2, call them up. If they do not have a copy, give them a copy. Inform us at 2 that we have given the copy today. We'll give you 2 weeks. Is it lack of communication? Yes, sir.
No, my lord,
this-
we have already communicated, my lord.
So ask them. When you are not taking the initiative, we'll have to take the initiative.
day after tomorrow will be
Day after tomorrow, my lord.
Day after tomorrow. At the request of the learned counsel for the respondents, list this matter day after tomorrow
Lordship.
for them to obtain instructions.
Lordship.
Yes.
In this case, your lordship, the respondent unfortunately have filed their affidavit. Your lordship, grievance was that in this, we had paid from information from the RTI, through RTI, your lordship, said informations were not provided. The case is with respect to the Indira Awas Yojana. There were certain allegations by us and we had paid for some information. They said information were not provided, your lordship. We had filed an appeal. The appeal is still pending. That is why, your lordship, they have not filed any affidavit.
Appeal was disposed of on 12/12/2023. Petitioner Azizul Haq is present. In his presence, Lordship, this was, I'm guessing it before, Lordship.
12/12.
2 years back. That was the appeal preferred, Lordship, because of the non-compliance. And the petitioner was also present on that date.
He filed the writ on 8th. He filed the writ petition on the 8th day of December. And the disposal came on 11th day of December. The affidavit is of 8th.
Let my learned friend get that instruction.
Would you like to have some instructions with the lady?
Next
But your
week,
lordship,
Let my friend get.
yes,
the
yes, I'll get my instruction.
Instructions?
Or if necessary, Lordship, I can also provide a copy of this one, Lordship, to my learned friend.
Yes, your lordship, a copy may kindly provide it to me.
Because this order says there is a contradiction between the stand taken by SPIO and petitioner. So BDO Hajo was asked to make an inquiry.
So,
You would like to go through this?
the prayer made by my learned friend has already been taken care of. His only contention is that appeal is to be disposed of.
Dispose of, your lordship.
So it was disposed
It
of.
was disposed
Yes,
of.
yes.
You may like to
So-
have your instructions.
Yes.
Can you give him a copy of
Lordship.
this?
Lordship may keep it as a part of the record.
No, he will require a copy to ask this.
Lordship, I will make a photocopy and I will give you.
Heard Mr. T. Devi, Learned Counsel appearing for the petitioner also heard. Oh, you're appearing for, sir? Mr. Sharma, you're appearing
Lordship, I am, Lordship, let me check.
Respondent number
Number 3, 4 and 5.
3, 4 and 5.
Lordship.
Three standing councillors.
Huh?
Three standing councillors. Four.
Declared in the
Lordship
repetition was
Four
for
upon.
Earlier, Lordship, we appeared on behalf of 3, so I have placed that instruction, but my learned friend has stated that now they have got standing counsel.
Standing council is there for three.
was here for
D
information.
Dega, my lord.
Ah,
All this is reflecting also.
Anyway,
So Lordship, my name may not be reflected in for.
so you are appearing only for 3.
Four.
For the respondent number 4, only 4, huh? The respondent number 4, full stop. The Learned Counsel has placed before this court an order dated 11/12/2023.
12/12 to 23. Order is dated
Or
12.
12/12/2023, which has disposed of the appeal filed before the Assam Information Commission. Full stop. Mr. T. Devi requests for an accommodation to have instructions. The matter from the petitioner. Full stop. List this matter again. You want a fixed date or can it be?
Month of December, January, January, your lordship.
Again, on the on the 9th of January 2025.
Deeply.
2026.
But I am appearing for Panchayat department.
The instruction may be kept.
I am
as a
appearing
part
for
of the-
standing Panchayat department.
Department and a copy of the order dated 12/12/2023 produced by Mr. Sharma is kept on record and marked as X. X at a mark kore dibo, flag mark ekhon dibo.
Much obliged, Lordship.
Obliged.
Yes. Matok.
I see.
What-
Is it-
what
it
is-
is-
what is-
Yes, madam.
Lordship,
This is a matter relating, have you any information about this matter?
Lordship, since we have missed the matter because in the cause list, our names have not been reflected. my
Item
lord.
number
19.
19, madam.
Ms. So-and-so Learned Counsel appearing for the BPC authorities as their has submitted that the cause list did not reflect the name of the standing council
BTC.
BTC and therefore they are not, they have not brought the file. Is that the matter may be taken up after
2 weeks, my lord. If instruction is required, I would like to bring him.
after 2 weeks. Mr. So-and-so appears for the petitioner and has submitted that the matter is of the year 2023 and relates to compensation to be paid for land acquired. Full stop. Is this matter again after 2 weeks, date to be fixed by the registry, reflecting the name of standing council C in the cause list.
Well, she can obtain the instruction whether any compensation is paid to
Yeah,
in
by the
respect
way.
of document number 523 or not. Otherwise,
So first let her get a copy of the writ petition.
Yes, ma'am.
Then you will explain the writ petition in the court. You will have our answers to that.
Yeah, Lordship, I can take back the instruction.
Why not?
Obliged.
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 Yeah. 2021 or something, ठीक है. Yes, Mr. Ho.
Actually, my lord, it should have been listed along with WBC number 5292 of 2023, my lord.
5292 of
23, my lord.
2023.
Yes, my lord. There, my lord, similar other matters are there, my lord. So, my lord, actually, it was placed before the court.
Who appears for the
My lord,
PWD?
B. Gogoi was appearing, my lord.
What about the GST? You don't want to implement them?
Yes, I had implemented, my lord. The IA was filed, my lord, it was allowed, my lord.
Huh?
IA was filed, my lord, that was allowed, my lord.
Oh, this is the amended. Yes.
Commissioner of Taxation.
Lordship, I'm appearing on behalf of Mr. P. Nayak for PW. My colleague, Mr. Barwa needs to be here because he's appearing for tax.
Matter is of 2023. You have been kind enough not to file any affidavit in opposition. Now, if we pass an order, we'll be harsh enough. What to do?
Lordship,
No affidavit.
Lordship, not yet.
Heard Mr. Ashok, learned counsel appearing for the petitioner. Also heard Miss so-and-so, who appears on behalf of Mr. P. Nayak, learned standing counsel, PWD Assam. Full stop. Mr. Hawk has submitted that the number of the writ petition recorded as WPC number 5292 of 2023 should actually have been 5292 of 2023.
Yes, my lord.
Order में 5022 लिखा हुआ है. Recorded as 5292 of 2022 should actually have been WPC 5292 of 2023. It is noticed that the matter is of 2023 and the respondents have not filed their affidavit till date.
Yes, my lord.
Stop. Giving one opportunity to the respondents to file their affidavit to response to the writ petition. List this matter again in the third week of January 2026 along with WPC number 5292 of 2023. Is it disposed?
No, my lord. Not yet disposed, my lord.
5292 of 2023. Yes.
May it please us, my lord. My lord, they had implemented the GST authorities as respondent. My lord, accordingly, we have communicated with the department and when we have received our instructions, my lord. My lord, and our instruction says that, my lord, the GST registered number of the petitioner is not found in this petition, my lord. They have not mentioned the.
The learned counsel for the respondents have stated that they have received instructions to the effect that the GST registration number of the
petitioner is not
petitioners are not available in the writ petition and therefore detailed instructions could not be provided.
Yes, my lord.
Yes, Mr. Hawk.
My lord, my lord.
Bereft of material.
No, my lord, I'll provide.
Bereft of material information. Can we dismiss it?
No, my lord.
So, my lord, at the same time, it is difficult for us to make any submission in this matter as of now, my lord.
Full stop. The learned counsel for the petitioner has prayed for an accommodation
My lord.
to bring on record the GST registration number and other requisite details by way of filing an additional affidavit within a period of 1 week from today.
My lord. My lord.
Oblige, my lord.
Both will be same orders? Same orders. 2021.
Develop like.
May I please the lord? My lord, I'm sorry, my lord, I am
No issue.
10. So, my lord, what happened in this case? So, petitioner, my lord, before this honorable court for my lord, PMA wise, my lord, money not being released. So, pursuant to filing of the petition, my lord, all the petition are received except petitioner number, my lord, 204, 210, 211 and 171, my lord. For that, my lord, there was an order on 21/2/2024 for filing affidavit by the respondent. They have not filed any response. 21/2, my lord. There is an order.
If everybody else has received.
Yes.
And this no longer remains a common grievance.
Yes.
Why don't we dispose it of giving the liberty to the persons who have not received to approach the department, find out the reason, challenge the same if necessary.
My lord, since they are similarly situated person, my lord, my lord, as to why they have not really, that is why, my lord.
Understanding.
I understand, my lord.
This matter was allowed to be listed as a joint petition because everybody had the same grievance.
Yes.
Now, some of the persons have been allowed, some have not been allowed.
Yes.
Definitely there is a.
Before the last order, my lord, some of the person released, my lord. And after that, on 21/2/2024, response.
Can you take down the petitioner numbers and perhaps have a communication with the department?
Only that will do, my lord.
That will,
1 week time may be. good,
If
that.
if we have a
Because-
concrete reason why they have been denied.
My instruction is for 2023. It says, my lord, that some complaints were received by the department saying that numbers of houses were holding government and forest land. That is why that was hold, my lord, at that time. So up to that instruction is required for that matter.
Counsel appearing for Mr. JMH Chaudhary and counsel appearing for the petitioner has submitted that the grievance raised in this writ petition has been redressed for most of the writ petitioners, save and except for the writ petitioner number
204,
Huh.
210,
Huh.
211, and 171.
Full stop. He submits that all the other writ petitioners have received the PMA Y-G payment. Full stop. Mr. So-and-so and a counsel appearing for the which department, sir? You are
PNRD
appearing?
department.
Mr. Dutta, huh?
PNRD department.
The PNRD department has sought for an accommodation to have a communication with the department as to why those writ petitioners as named above have not received the
Second and
benefits.
third installments.
Have not received the complete benefits. We'll establish this matter again on 5th.
My lord.
5th of December 2025. Enabling Mr. Dotto to have his instructions.
My lord. I'll leave it.
May I please, your lordship? But in this case, my lord, we are appearing as legal aid counsel, my lord.
You are appearing as a?
Legal aid counsel.
Yes.
My lord, here, my lord, the petitioner on 30, my lord, annexure 3, my lord. Page 21, my lord, filed an RTI application under the RTI Act before the, my lord, Public Information Officer. At page 21, your lordship will find. But the authority, my lord, did not reply to the, did not furnish any information with regard.
How many
to the-
days delay was there? 1 year
My lord.
and 11 days, 11 months, 2 years. Near about 2 years.
Thereafter, my lord, first appellate authority. First appellate authority, my lord, your lordship will find. Annexure 4, page.
What kind of an information were you seeking, sir?
My lord, information with regard to the, my lord, allotment and settlement of forest land
Ah.
to the petitioners, my lord.
No, I did not.
In the
You are the
application itself,
petitioner, you want information regarding settlement in your favor.
not our favor, my lord, the allotment that has been given to the dwellers,
To the dwellers,
including the petitioners, my lord.
including the petitioners.
Petitioners,
Ah.
my lord. The status of that, my lord, allotment and settlement of.
Where
land.
is your RTI?
My lord, RTI is at page 21.
Was the reply given? No reply.
No reply, my lord.
Yes, who appears for the respondents? Notice was issued. You are appearing for?
Okay,
Yes, yes, what do you have to say?
Lordship,
Instructions are still awaited, Lordship, but I think the respondent number 2 is answerable.
No instructions. You have rejected the prayer for condonation of delay,
My lord.
saying that it is unexplained. Do you want to file an affidavit or should we allow the repetition?
Lordship, that was dismissed by the respondent number 2, Lord, for respondent number that was
For the respondent number 3 and
Three.
4. Very well. Then you don't represent respondent number 3 and 4. Do you represent respondent number 3 and 4?
Yeah.
No.
Yes, Lordship, but instructions are awaited.
Lord, the order impugned may kindly be set aside, my lord, and the delay may be condoned and they may be directed to furnish reply within a time frame. That is my-
Appeal will be considered on merits
That's correct, my lord.
by them.
Yes.
You will not make any directions for
Right.
furnishing any reply. You come back to the
Yes, on
content.
merit, my lord, within a time frame, my lord, as prescribed by law. That is my humble suggestion. Otherwise,
Take the
also,
heard Mr. So-and-so learned counsel appearing for the petitioner also heard.
Yes, and my lord.
Ms. So-and-so learned counsel appearing for the
KAC, Lordship, respondents 3 and 4.
all the respondents.
3 and 4, Lordship.
Respondent number 3 and 4, full stop. This writ petition had been instituted in the year 2023.
2024.
2020. There also you are a year late. This order is of June, you are coming in March.
Yes, my lord,
Huh?
because they, my lord, communicated to the Legal Aid Services Authority, my lord,
No.
and they approached the, my lord, Legal Aid Service Authority. Legal Aid Service then.
Where is that explanation? Anywhere?
But that
In the writ
is not
petition,
there,
no.
but we have a letter, my lord, whereby
Not on
we have
record.
been authorized, my lord, or allotted to.
What did we say? Has been instituted by the 2023 or 2024 challenging an order dated 17/6/2023 passed by the Assam Information Commission, rejecting the appeal of the rejecting the second appeal
Secretary.
filed by the writ petitioner before the commission, holding it to be time barred and the reasons given for the delay in filing the second appeal being not found to be satisfactory. Full stop. The learned counsel appearing for the petitioner has submitted that the grounds of delay had been explained in the petition praying for condonation of the delay, full stop, wherein it was stated that the second appeal could not be filed on time since the disposal of the first appeal had not been informed to the petitioner. Full stop. The petitioner had to thereafter seek legal assistance from the Assam State Legal Services Authority. And due to heavy rainfall, flood and poor connectivity in the area, was not possible for the petitioner to come to Guwahati from Karbi Anglong to file the second appeal, full stop. It has been further stated that the concerned counsel appointed for legal aid was not keeping well, and therefore there was some delay in filing the second appeal under the Right to Information Act, full stop. The learned counsel for the petitioner submitted that the delay ought to have been condoned by the concerned authority, and the second appeal required a decision on merits instead of being stopped at the threshold on the ground of being time barred, full stop. Notice was issued in this case on P42024, and there is no representation, there is no affidavit in opposition filed by the respondent number 3 and 4, full stop. Although the name of the learned standing counsel for the respondent number 2 is reflected in the cause list, there is no appearance today, as was there no appearance on 29/10/2025. Stop. We have gone through the grounds given in the application for condonation of delay in filing the second petition, and also have gone through the contentions raised in the repetition. The matter relates to
Allotment of forest land under the provisions of land policy framed by the government of Assam.
Place this matter again in the month of, cut it all. Place this matter again in the month of January 2026 on a date to be fixed by the registry.
But I'm sorry, Milord. Milord, I'm extremely sorry, Milord.
Lordship.
Utte place this matter again in the month of January 2026. Third week of January 2026 on a date to be fixed by the registry. Yes?
In this matter, my lord, we are led by Mr. R. Borpujari, my lord. He has arisen some domestic issue right now, my lord, so he has to leave the court. So we may be accommodated after 5th, my lord, that as senior counsel has some difficulty till 1 to 5.
If can be kept after the 10th or the 10th of December.
A request has been made.
10th, my lord.
To item number 20.
25 and 26.
To RTI matter a request has been made on behalf of the learned counsel,
R. Borpujari.
on behalf of Mr. R. Borpujari, to accommodate the matter for a period of
There's some personal difficulty.
for a period of 10 days.
10 days.
Let this matter again be listed after 10 days.
Uh,
Today is 26th, 10 days would be after the 5th.
Lordship, 10th of December or after 10th?
Let this matter.
Let the matter be
Again?
fixed on 10th, my lord. We have little urgency also. There is urgency. There is some urgency. But
On
we-
11th of December. 11th,
11,
the Thursday, 11th,
my lord.
11th of December 2025 for further, for consideration.
Lordship, I'm appealing for the respondent number 9 in this
Yes,
matter.
yes.
P. Borua.
P. Borua. Keep it in bold. He's made a mention. So.
Interim was there, my lord, on behalf.
Huh? He does not want it. Why? Maybe interim order to continue.
May I please, Lordship?
My lord, before my
Oh, yes,
learned,
that matter.
my lord, before my learned senior friend starts, my lord.
Yes.
My lord, we have filed our affidavit in reply today, my lord.
Okay.
So, let the matter be taken up, my lord, Friday next, along with the affidavit filed by us. My lord.
Yes, so
No
they filed
copy
an
has been served to us.
Copy has not been
No.
served.
We're serving, my lord. It's
My
there with
lordship,
us.
this additional affidavit was filed by the petitioner lordship that was served to the learned friend in the month June itself, Your Honor. Thereafter, my lord, so after 3rd of June, 18th, and 18/8, then 14/9, then 3/11, 7/11. Today, 7 dates
What-
have gone.
We-
That question,
If I remember correctly, we had heard this matter on the last occasion, trying to bring it to an end. And now he has filed an affidavit, which he may like to rely upon on Friday. Today is Wednesday. He is asking for Friday,
okay.
for the affidavit to be on record. We'll allow that. It will be on Friday along with this affidavit.
Okay.
At the request of Mr. B.K. Sandana Council appearing for the respondent, list this matter again on Friday. Friday would be 28th of November 2025 along with the additional affidavit.
No,
have
I
filed.
think affidavit in
in
opposition
reply.
against the additional affidavit.
Affidavit in reply to the additional affidavit filed by the petitioner.
Petitioner.
Additional, he is filing a reply to the additional affidavit.
Correct,
Just
yes,
filed.
correct.
Obliged.
Obliged.
My lord, there are three petitions, my lord.
Ah,
Three petitions for payment of contractual dues, my lord.
Prothom petition.
Item number 29 and 31. There has been no response filed by the state. In item number 30, the state has admitted that they're processing my case. So, my lord, maybe they'll need some time to come back with their comments, my lord.
on 20, on
20.
30.
Item number 30.
No, item number 30.
Yes, my lord.
Yes, Mr. Gogoi.
My lord, in
No, we'll have to keep the three items together.
45252.
Could do?
452.
Yes.
I don't know.
Yes, yes, yes.
My lord, this can be disposed of in item, this item 30.
4552 is item number 30.
30, my lord. Item number 30 can be disposed of. We have admitted the claim.
Okay.
There was some delay on their part also, so which also led to delay in processing.
Don't give him the interest.
It's not asking, madam.
Don't give him the interest. If there is a delay. Yes, item 30 likha tha. Mr. M. Sharma, learned counsel for the petitioner. Also heard Mr. D. Gogoi, learned counsel appearing for the
PHED, my lords.
HE department. Most of the present writ petition had been instituted, claiming that the petitioner was not paid the admitted amount, which
5
he
lakhs.
claimed
Yes.
as bills
Yes.
for work executed
Yes, my lord.
by him
Yes, my lord.
for the state authorities. Full stop. The authorities, the state respondents have filed an affidavit in the matter whereby it is an admitted position that the petitioner is entitled for payment of rupees 5,30,000.
30,000.
Huh?
30,000.
Did I
5
say
lakhs.
something else?
5 lakh 30.
5 lakh 30,000.
5,30,000.
Yes, yes, I apologize. I heard.
A little while ago, we had cancelled an entire order because there were interruptions from the council.
I apologize. I apologize. I apologize. No,
You correct me if there's anything wrong. You correct me at the end of the
my
offer.
lord, noted, my lord.
Listen to you, huh?
Noted, my lord.
Mr. Gogoi has submitted that the process is underway to make payments to the petitioner. By process is underway to make the payments to the petitioner as entitled to him. Up in the above and in the line of
Subsidiarily.
is also disposed of, directing the respondents to make payments of the admitted amount to the petitioner within a period of 6 weeks.
If Tamsarili comes, then time goes. Huh? It will chronologically, my lord.
We will not say Tamsharli, we will say what are the Tamsharli part?
It might not be.
The respondents are directed to take expeditious steps to make the payment of admitted amount to the petitioner. What time living?
5 lakh 30,000.
Immediate
Small
time.
amount. It's a small amount for them, my lord. They
In a
are.
period of 6 weeks.
6 weeks will be, my lord.
8
8 weeks. 8 weeks.
8 weeks.
8 weeks.
What about the other two?
My lord, no response.
One we have received the
Please
parawise.
dispose of, huh?
One is I have received the parawise in 455.
4557 is item number
Admitted
31.
or not?
Admitted.
Instructions.
Admitted, madam.
Admitted. You have to
Has
file
to-
an affidavit.
Yes, my lord. Has to be put on affidavit otherwise.
29 and 31.
My lord.
M. Sharma, legal counsel for the petitioner, D. Gogoi, legal counsel appearing for the PC department has submitted that he has received instructions and would like to bring the same on record by way of an affidavit. Full stop. Prayer granted, list the matters after 2 weeks on a date to be fixed by the registry along with the affidavit proposed to be filed by the respondents.
My lord, I'm grateful, man.
Yes.
Told that they have filed the affidavit in opposition today.
Hmm.
Copy has been served upon me, whether they have filed or not, I don't know. Day was fixed for filing affidavit. They were directed to file affidavit in opposition, and thereafter we were directed to file our rejoinder.
You want to file a rejoinder? Have you gone through it?
We'll have to file a rejoinder, Your Honor. But the copy was served to my clerk, Your Lordship, but I have not received the copy yet. Over phone only I have been informed.
Is there any urgency in the matter?
There is urgency in the
Regarding what?
regarding permission for extraction of stones in the Mahas, Your Lordship. Your Lordship, may produce the last order, Your Lordship. 24/10/2025 order. Your
The permit was till 30/12/2024.
I approached this honorable court before
Now,
it was
do
valid.
you have any interim order?
No, Your Lordship.
Then the permit is expired.
Expired, Your Lordship.
As of today, what relief can?
There is a prayer, Your Lordship. I also have prayed that at least for the tenure in which they have illegally stopped me from extracting the stones, at least for that period, I may be permitted again to extract the gold. Because there is an order, I have, if Your Lordship may kindly come to pay. The purchase order is there at Annex 5, Your Lordship has taken up WPC 6697, Your Lordship.
Yes.
Page 26, Your Lordship.
Purchase order.
Yes, Your Lordship. So we'll have to fulfill the purchase order there. Otherwise, there is a clause for penalty also, Your Lordship. And from 11/7/2024, even though at that time the permission was very much valid, I was not permitted to extract the stones or even to pay the royalty.
Get the permission up to December, so you would have another 6 months.
Yes, Your Lordship. At least for that period.
This who appears for?
NC Hills Autonomous Council, Your Lordship. Dimaso.
The Hills. So this can get item kiman ito? You have to respond to it. Mr. P.K. Sharma, Learned Counsel appearing for the petitioner has submitted that he has received a copy of the affidavit in opposition filed by the
The respondent number.
proposed to be filed by the respondent number.
Also, I don't know.
You don't know. Filed on behalf of the respondents, full stop. The affidavit is not on record and there is no representation on behalf of the respondent number 2, 3, and 4. 2, 3, 4, and 5. Full stop. List this matter again after 2 weeks, by which time the petitioner may file his response to affidavit in opposition, if any, filed by the respondent authorities. Both of them.
Fix a date. Your Lordship.
Both of them. There are
Both
two
same,
petitions.
both same. Yes.
Same orders, na?
Same order, yes.
কি করলো list the matters after 2 weeks on a date to be fixed by the registry.
Obliged, Lord.
In this matter, petition matter, there was one contractor's payment to be paid. In this writ petition, the contractor's payment against his work done. The work is already admitted on the previous order. It is admitted by by Mr. Gogoi, additional advocate general. Now, Mr. Lord, mother of the petitioner is very serious one. This is cancer patient. The hankering after money from here and there. But the work was ordered to be completed within 15 days, and exactly within 15 days, he completed the work. There's a completion report is there in the annex 2 and 3, madam.
Yes, sir, any instructions?
I received on 25/11/2025, that is yesterday. That one paragraph instruction, Lordship. It is admitted, Lordship, but for want of fund, Lordship, they are now unable to pay them at this stage. So Lordship may dispose it of in terms of Tamsir Lordship, PW matter.
That was what was reminded to us by D. Gogoi just a few minutes ago. Take its own turn. Tamsir Ali.
So
But they're bound. He has fairly submitted. Amount is admitted.
Yes, madam.
But as per Tamsir Ali, dispose it of only in terms of
Yes, madam. Not the dispute of giving it.
dispose of, na? We'll pass the orders. Law. Dispose for Tamsir Ali dispose. Huh? The admitted amount. We can keep a copy of this, Mr. Naik?
Lordship.
Dispose the divided or disposed. What did you do? Huh? Disposed of, we are allowing the repetition in terms of Tamsir Ali.
In terms of Tamsir Ali, but Lordship will not, in my understanding, Lordship will not fix any date that within this period I have to pay.
No, madam,
Sir,
that is
that's
have
not
to
a
be given. That is have to be given. I need money very urgently. It is the matter is
understand,
now within a maximum within a month.
That is
His mother is cancer sitting in the bed. Everything for getting money for
Let me put it
treatment.
this way, sir. Let me put it this way.
Yes, madam.
If you want an execution of an order which can be executed after a month, this is not the forum. If you are saying that by Tamsir Ali,
No, that is not. Yes,
this is
I
the
have
forum.
understood it. I have understood simply for urgency of money. I am.
Tamsir Ali, according to us, it is very clear that it will go turnwise.
Yes, madam.
A person who completed the work after you will not be paid before you. That is the best we can do.
Yes, madam.
Lordship, petitioner is Roy Medhi Lordship. My senior colleague is also Roy Medhi Lordship. So it is quite unbelievable that for one top 6 lakhs rupees, mother's treatment is delayed. That is just not believable.
If she sees, look
In
that
fact,
now.
in fact, he is my
That,
neighbor Lordship. I know
that
that.
will be verified. Yeah, make me patients imagine all the patients are there, prescriptions are there.
Mr. Nayak, as a neighbor, is assuring that. best
Yes,
effort
my lord,
will be put in,
yes.
Don't worry. Yes, next.
Obliged, Lord.
35. Wow.
May I please, your lordship?
Yes.
Lordship, the matter pertains to non-payment of my security deposits, your lordship. We have filed our, they have filed their affidavit, lordship. We have also filed. Readings are complete, your lordship.
Yes, sir. Why not the security deposit?
Page 54 is the reply, madam. Page 54, Lordship.
54?
Yes. Part of the affidavit that we have filed on behalf of respondent number 3. Lordship will see the first para of page 54. Now it has been extended till 23/3/2027. So it cannot be, otherwise, madam, if they agree, they will have to challenge this order. Without that, it is on record, madam.
Lordship.
You completed the work late.
No, your
So
lordship.
the
No, the maintenance was not done properly, so it has been extended.
Work was completed on time, your lordship.
Maintenance.
Lordship will come to page 38, your lordship, of the writ petition, your lordship.
Yes.
38.
This
is the completion certificate that was given to me, your lordship. It was issued to me.
True.
Yes, your
The
lordship.
work has been completed.
Yes, your lordship.
Even though we are on action, will still say so.
Lordship.
This High Court was completed.
Lordship.
In the rainy seasons, you see a few buckets in the corridor.
Lordship.
So now the government has taken a policy where not only you complete the work, you maintain the work.
Yes, yes, your lordship. The
So
maintenance.
that maintenance work
Yes,
was not done properly. It has been extended till 7/3/2027.
27, your lordship. Lordship.
So till such time your security deposit has been held up by them.
Lordship.
Is there a challenge to that order?
Lordship.
If not, would you be required to challenge that order so that this court can assess the merit of your challenge?
Lordship, may I just, Lordship, I do agree, your lordship. May I just place it in this way because, Lordship, the maintenance period was over by 23/11/2024, your lordship. 5 years maintenance period was over. And after that, I was given the certificate and till what time will the maintenance period will extend? It has been stated in the document, your lordship, the bid document, your lordship.
Yes, page 30th, they say that the maintenance work
Yes, your
No,
lordship.
Lordship will see page 53.
53.
Yes. Beginning of the letter.
53, your lordship, lordship, in their affidavit in opposition, your
There are two,
lordship.
my lord.
Unsatisfactory performance details due to less than 80% marks in physical. Is this PA? Then, Mr. Gogoi,
My lord.
once you give him a certificate of completion.
Yes.
No, no,
of
completion
maintenance-
is, my lord,
No, no, maintenance. If you see page 30th for a moment, that is where I was also. Last 3 lines, if you see. Package number AS 11-87, you find that line thereafter? Completed the execution of maintenance work.
my lord.
Did not.
But-
So now let us say that this was an order. It may be a wrong order, but he had an order saying that the execution of maintenance work is complete.
My lord.
Then you come up with this letter of 15/5/2025,
25.
around 20 days later,
My lord.
saying that no, it is not up to the mark.
My
Did not.
reply to that is at page 48, para 7. We have countered to that para. Because this annexure is part of para 9,
Page 48.
48 of the affidavit.
Yes.
Lordship will see, the deponent begs to submit that the petitioner has applied the release of the security deposit money on 15/3/25, and accordingly one draft was prepared to the empowered officer so and so regarding release of the same on so and so. It is also pertinent to mention that during the routine maintenance period from 24/11/2023 to 23/11/2024, the petitioner has received zero payment bill due to non-maintenance of the road and due to unsatisfactory performance during the maintenance period. The package was extended for 28 months.
Now,
That is so and so.
after once he has been given that maintenance completion order, will it be open for the department to simply say that you did not maintain it properly, so we are simply extending it? Can that be? There, I think, has to be a notice, or there has to be something to tell him that yes, that certificate issued on 24/4,
My lord.
we are not agreeing to it. Come and explain to us. There must be something.
Yes.
Then this extension has to go. If the extension order goes, then the security money.
And your lordship will come to page 66, your lordship. The maintenance bill was also given to me, page 66 of my affidavit in
You
reply.
paid
your
the
lordship.
maintenance bill.
Maintenance bill was
Only
given.
holding the security money, is it going to help in any way? Is it not trying to arm twist him? Because we have the security money with us, we'll make you work and work and work.
And your lordship,
Yes.
lordship, the-
Yes, my lord, page 30, next page 36, 37, 38. These are the 3 documents.
So now all these documents having been given by your persons,
My lord.
can we simply say that after that, during routine maintenance, you find that no, there were some mistakes. Your engineer who's giving the certificates is not being put to task.
No, this has been furnished.
Huh?
My lord, the para-wise comment has been furnished by the chief engineer.
Yes. We have no doubt the chief engineer is acting with the best interests of public money.
My lord.
But without a notice, withholding the security money when all other payments have been made. Security money, suppose is ransom money.
My lord.
He can be asked to refund back whatever he has got. There are other ways of doing it.
Lordship will have to, my lord, examine the tender conditions also, my lord. What
Is it? Show us.
Yes, that part, my lord, is not annexed to the reputation, my lord.
Maybe, but it would be upon you to show that even after giving a completion certificate, releasing the money for the maintenance, whatever he was required to be paid for the maintenance, after releasing everything,
yes,
then you can come back to say that no. We'll hold up your security.
No, para 6 in that case, Lordship will see para 6.
Yes, which one?
Para 6, page 47.
47, yes.
Says that to submit that as per the SOP of the E-Mark, which is the portal developed by NRDA in association with the National Informatics Center to monitor electronic maintenance of rural roads during the routine inspection of the road and performance evaluation of the same. For mentioned bi-monthly periods, the package performed unsatisfactorily due to which, as per the system, the package got extended for 28 months. The process of system generated DLP completion certificate. An extension of package which performed unsatisfactorily during their DLP period was conveyed via so and so.
That conveyance is not on, not.
Page
referred to.
number, my lord, 55.
This is after that certificate, sir.
No, but my lord, it's the system generated page 58, lordship will see.
50?
58, last annexure.
Lordship, this is just a draft demo, your lordship, is it?
No, it's system generated. It's not something, my lord, that.
Is not with
Lordship-
his, is it with his? Package number so and so contract, you are Pragati Construction,
No, your lordship.
you are not Pragati
No,
Construction.
your lordship.
Oh, if you depend on this, then you are depending on
No, no.
someone else's document. Mr.
But they.
I'm Tapas Kumar Ray Chaudhary, your lordship. Lordship, may I submit, your lordship, this document, 30 April 2025, your lordship. This has been, we had already completed our work in the year 2024. And how can this mechanism be introduced or used in my case, your lordship? Because this will not be, this cannot be applied, lordship, retrospectively. It will be prospectively, your lordship. I completed my work, a defect liability period was completed, a certificate was given to the defect in the year 2024, your lordship. Now, how can they?
And then you were depending upon case 55, 30 April
30
2025.
April 2025, your lordship.
You
This is
pointed out 30 April, did you?
Yes.
30 April
Let us have the
2025.
first paragraph. Engineer shall give notice to the
notice, your lordship.
contractor of any defect before the end of the defect liability period, which begins from the completion date and ends after 5 years.
Lordship is not a pedaling.
Page 55, para 1.
As you are aware of also, it is 32.1. Clause 32.1.
Yes. Engineer will have to give the notice prior to the end of the defect liability period. Now, this defect liability period, prior to that, he did not give any notice of defect, but he has given a certificate saying that the maintenance is completed. You are recovering something from him by following due procedure of law. We are not against that.
My lord.
Holding up the security money in the manner it has been done.
That, my lord, whether notice has been issued or not, that part I can have.
It is not stand in the affidavit. You had your scope.
My lord.
You had your scope in the affidavit in opposition to say that this was with notice. He knew that we are going to hold it up. He replied so and so. He did not reply. Something would have come.
My lord.
Did not. From para, you were reading para 9. No, not 9. Para 9. Para 7, which you were reading. One draft was prepared, the empowered officer and chief engineer.
My lord.
During routine maintenance from 24/11, see, 24/4/2025 is one date where you had prepared the draft, not paid to him. I am reading para 7 of your affidavit.
My lord.
24/4/2025, you prepared the draft. Maintenance period, routine maintenance period was from November.
My lord.
April to November, no notice. Is it? And then you suddenly come down with that other letter saying that now we are holding it up.
Just below that, my lord, it is also pertinent to mention here in that during the routine maintenance period from 24/11/23 to 23/11/24.
Okay.
The petitioner has received zero payment bill due to non-maintenance of the road and due to unsatisfactory performance during the maintenance period, the package was extended. So there is a, my lord, statement that there is
The
unsatisfactory.
certificate says otherwise. The certificate which was shown to us,
38, your lordship.
page 38, says otherwise. Again, page 40, if you see, liability period is over.
Lordship.
Page 41. Yes, sir. I think we can give it a quietus. In case he has not maintained it properly.
My lord.
make
And why
recoveries
this
from-
was issued, my lord?
you make your recoveries from him, make him pay for you, hold up your executive engineer, the chief engineer, everyone, why they allowed this to happen. Making only him liable, what is the amount of security deposit? He must have not have participated in any tender process after that.
Total amount is 12 lakhs, your lordship, 12 lakh 36,000 and 32.
Well, let me have the clarification for once, my lord. On Monday in that case, or Friday, Friday it will be, yes, Friday I can have it, my lord. Before it is on Friday.
But only clarification you would give us is
Yes,
from the date when that liability, if any,
notice was issued.
if any notice was given before end of the liability period.
My lord.
No notice, then the liability certificate stands. No
Yes.
liability certificate stands. Second issue will be before you issued that holding up of the SD, any notice given to him.
It says, my lord, it is a system generated. Automatically it generates, my lord. That's why.
Someone must have fed some information to
To
it.
the system, yes.
He must have some notice of it.
Yes, your lordship,
That
because
this has been fed, sir. We are going to feed this to our system.
Well,
Artificial intelligence will remain
yes,
artificial.
sometimes.
It will remain artificial. It cannot overtake the human mind. Is this matter again on 28th of November
Yes,
2025
let it be on Friday.
to enable Mr. B. Gogoi to have his instructions on the queries raised by this court. This we are returning it. The clause is already quoted.
Lordship. No, then I will
But it
procure the
will be
entire
already
matter contract agreement. I will procure the entire contract agreement. I will place it on next week.
No,
Obligation.
what the contract says, we are not interested now.
Yes.
We are interested only in liability ends.
Yes.
He has a certificate.
My lord.
You impose a liability without a notice.
Lordship.
That is the entire thing we have to see. The
Yes.
contract ended the moment you gave a certificate.
My lord.
Contract period over, contract over. Comes to an end.
Lordship. No, let me see, my lord, who can issue the certificate and all, my lord. I will come up, my lord. Let the
In your affidavit, you said engineer will do it, empowered officer.
I am part of it. In fact, my lord, it is entrusted, my lord.
Empowered-
Delegated to the executive engineer.
Empowered, don't take away powers now for one case. Let it remain with you.
obliged, your lord.
Obliged.
Yes. 6.
May please your lordship. My lord, I am appearing on behalf of the private respondent, my lord. So my lord, I need some time, my lord. I pray for some time to file my lord affidavit.
To file the affidavit.
Yes, Lord.
What is the case, sir?
My lord, the case is regarding challenging the election of the president and vice president of the Anchalik Panchayat, my lord.
You were not elected
I am not elected.
and he is elected.
He means he is also appeared. Oh, then he is elected.
You are for respondent number?
My lord, I am
All
responsible
these
for 8 to
private.
8 to 16, my lord. All the private respondent.
8 to 16.
8 to 16.
How many private respondents?
My lord,
9.
8 to 16.
9 private respondents.
9.
Yes.
How many writ petitioners?
My lord, writ petitioners is 8.
Maybe on a losing ground.
No, my lord, this
Huh?
is not the ground.
9 respondents and 8 petitioners.
8 petitioners.
Strength of the house.
And my lord, actually similar issues, this honorable court has already been settled, my lord.
Saying what?
Said that the rule 41(1) has not been followed. The meeting notice was issued on 14 here in this case, and the meeting held on 19. And as per rule 48(1), my lord, it has clearly written that the 7 days prior notice has to be served to the members of the elected members.
So why don't you sit on a bench show on a date fixed by the court?
Yes, my lord.
Any objection?
My lord,
Yes, my lord.
Fix a date.
My
Sit
lord.
for your strength of
My lord.
Yes.
show of strength. Whoever wins.
The last direction was given same method.
No, my lord, I'm trying to file affidavit, my
This is
lord.
election.
My lord,
Either you have the support or you don't have the
my
support.
lord, one opportunity, my lord, at least, my lord, I may be given.
My lord, a short date may be given.
Sir, M. Islam Learned sorry. The order, last order.
Yes.
Mr. M. Islam
My-
Learned Counsel for the petitioner
Respondent,
submits that he has entered appearance on behalf of respondents.
my lord.
He will argue from both sides. Who will argue? The last order says M. Islam Learned Counsel for petitioner
My lord.
enters appearance
No, no.
on behalf of respondent.
Respondent,
Mr. M. Islam Learned Counsel appearing for the respondents.
8 to
Number
16.
6 to
8 to 16.
8 to 16 has prayed for an accommodation of
2 weeks, my lord.
don't give him
My lord,
7
I
days
need some
notice.
time to obtain
Yes.
instruction, at least, my lord.
But it may be on 8th of December.
2 weeks to file his affidavit in opposition to the contentions made in the writ petition, full stop. Is this matter again on 12th of December 2025, along with the affidavit proposed to be filed on behalf of the respondent. Petitioners would be at liberty to file their response if any.
Yes.
Since urgency has been
Much up.
Fine, your lord.
due to urgency shown by the parties.
May I please, Your Lordship? And I am appearing on behalf of P. Rahman, my lord. For the timing, it may be adjourned, my lord.
Time being.
Obliged.
May I please, Lordship? On the last occasion, the 6th time for filed affidavits. AU, from Agriculture University.
Is your case?
My case is some bill settlements and lease regarding on lease.
Read the matter. You have not read the matter. But you'll say they have to file affidavit and
No, last order is like that only.
could be. Without their affidavit, maybe you'd have had a good case today. Was it not an opportunity?
Yes.
Standing council AU এটা scroll দি থলো দুটো এবারে তাৰপিছত next মাহটোতে
Please, Your Lordship.
Yes.
Lordship, it is a case of cancellation of the GST registration for non-furnishing of the returns, Lordship, non-filing of the returns. Lordship, thereafter, they have seized all our bank accounts, Lordship. So we are in a lot of trouble right now, Lordship. So we have, Lordship, up to the date of cancellation of the registration, we are able to file the pending returns, GST returns. We have filed those, Lordship, and we have paid the GST dues. In respect of the subsequent dates, Lordship, we are not able to file the returns because the GST registration is cancelled. We are ready to file the returns and pay all the dues, Lordship. And they have, in their affidavit, they have stated in page 150, Lordship.
What?
They say that the act does not, the only legal grounds for defreezing are number one, payment of tax dues, Lordship. So we are ready to pay these dues, Lordship. So, and the only obstruction is that the cancellation of the GST registration. In respect of cancellation of GST registration, there are several orders of this Honorable Court where this Honorable Court has allowed the restoration of the GST registration.
Lordship, first of all, the GST registration cancellation, Lordship, he didn't submit the return periodically. And Lordship, on that basis, his GST registration was cancelled. There is provision under the act to go for appeal. He didn't approach the authority. Thereafter, there was amnesty scheme That also he didn't avail, Lordship. So the demand was placed before him. And there also there was non-cooperation, Lordship. Now, whatever he has paid and the subsequent interest or that will be levied, my humble submission at this stage, Lordship may keep this case pending. Let him first of all approach the authority. Thereafter, they will have to calculate everything. Lordship, thereafter, Lordship, if he pays it, then we can remit it back before
Pays
your
it
Lordship.
from where?
Lordship,
Pays it from where?
he will have to place it before the Tinsukia.
He pays it from where? From his pocket?
Yes, Lordship.
That pocket you have stitched up. Account is
It's up
stitched.
because of his
When the account is, let us be
Failure.
practical, Mr. Chaudhary, we are not saying. that we-
Lordship, since there is a fraud, section 83 gives that power.
Listen to us. We are not concerned or we are not interfering in the freezing part. We are not saying you did a bad thing, you did a wrong thing, you did an illegal thing. No, we are not saying that. You are saying that this matter can be solved if he pays up the dues and the penalty. The account is frozen. Practically, from where will he pay? When the
Lordship,
bank account is
that
frozen,
he will have to pay because
then he will have to take a
because
gun and use the
in
street
the
and collect money.
no, Lordship, in the SOCOS we have stated, we have come across the transaction that he has
All
made.
done.
It's a fraud.
It was all wrong. You will have your calculation. You are calculating it at 100 rupees. He has to pay as the liability and 100 rupees as the penalty. 200 rupees he has to pay from where?
Lordship, first of all, he has to approach the authority as per the provision. He has not gone before the authority.
No, I have gone, but I am barred barred from filing an appeal.
Why?
So, because the period for which the delay may be condoned for filing an appeal is up to 1 month, Lordship. That is provided in section 107, subsection 4. If I may just read it, Lordship.
It is more than 1 month. Then what happens?
So thereafter, I cannot, if I approach the authority, they cannot condone the delay, Lordship.
Cannot.
They cannot. So that has happened
Lordship,
earlier also.
thereafter also, not only in his case, Lordship, lots of other cases are also there. The government, central government itself provided an amnesty scheme, which the state, he didn't approach. And Lordship, one thing is that, Lordship, there is a problem issue over in the Tinsukia district where a particular person has defrauded many.
This man?
Not only him, many other. Lordship, he is supposed to be an accountant of each and every one.
The person who files the returns, Lordship,
And he is saying that he is ignorant and everything. So, Lordship, that's why I'm praying. Lordship, let him first of all, Lordship may keep the case pending. I'm not, let him approach the authority because not even a single time he has approached.
No, I have.
Will observe in the order that you would approach the authorities. We will observe in the order that the authorities would and you would try to bring about a solution since you are ready to pay and they are ready to receive.
Yes, Lord.
Or should we send you to no? This is mediation, no?
No, Lordship, let it be because
you to have a talk first.
it will be Assistant Commissioner of Taxes, Tinsukia Unit.
Technically, they will have to allow me to file
They cannot condone per the act.
No, for the
amnesty, he has
appeal-
lost most of it.
yes,
He has lost all chances.
all
Now-
chances.
Now, what are the chances that the government can have its dues and he can also run his business?
Lordship, two option is there. As per, he will have to pay all his dues.
He's ready
Then
to do that.
he will have to take new registration. That Lordship authority will provide. New GST
It
registration.
is, where does he pay the liabilities? The earlier registration number is gone. So the new, the liability now he wants to pay.
Lordship,
Immediate is
even
what?
if it is as per the act, even if it is cancelled, he has to pay the dues. That will be that procedure part, Lordship. For that only I'm
That is
praying
one
that
part. And the second part, he can give you a check. He can give you a check.
whatever.
He can give you a check.
But the
Unless you defreeze the account, the check will never be entertained.
But my instruction is because it has
Catch
to be
22, this is called a catch
catch
22
22
situation.
Lordship, my instruction is that
If he gives a check,
he has the payment part has to be calculated since now more time has elapsed. Lordship, let him approach. Lordship, if he can approach within this 3-4 days by next week, I think I will get the response, Lordship. Then I can.
I will approach her. They will only have to allow me to file the return to calculate the tax. I cannot do that now because post the date of cancellation, the system does not allow filing returns.
you give it manually.
I will, if
You
they-
give it
I will do
manually, let
whatever.
them calculate.
Lordship.
Yes, sir.
If they are not allowing it in the computer system, then it is back to the calculator system. Why do you worry about it? Yes, after some deliberation in the matter, the learned counsel appearing for the petitioner as well as the learned counsel appearing for the respondents have submitted that the petitioner would approach the assistant commissioner of state tax, Assam Good and Service Tax, Tinsukia Zone, Tinsukia, that is the respondent number 4. The proposal to have his dues calculated. Have his dues calculated and made known to petitioner, after which it would be possible to initiate a process of payment of dues if necessary and to have the matter sorted out amicably. Accordingly, list this matter after 2 weeks on a date to be fixed by the registry, allowing the petitioner to approach the respondent number 4, full stop. It goes without saying that this court expects the respondent number 4 to cooperate so that dues recoverable can be assessed and placed before this court.
Lordship, let it be 3 and 4. Lordship,
3 and 4.
3 and
Respondent number 3 no koi 4 no koi 3 and 4.
I'm seeking a lordship indulgence, my lord.
Yes.
Number 32 and 33.
Yes, ma'am.
Actually, we are filing the affidavit today. But non-appearance has been recorded.
33 and
We are
34.
filing it today, sir.
Huh? Oh, NC Hills.
NC. Filing
32 and 33, na? Someone appeared for that matter. Okay, we'll record your presence. We were later on, Miss submitted that she was engaged in another court and therefore could not appear when the matter was called. However, the respondents are filing their affidavit in opposition, are in the process of filing their affidavit in opposition. Oh, rest of the order remains the same. Will that do, ma'am?
Bless you.
Thank you.
Much obliged.
Yes, any orders?
My lord, this is the similar order.
Have you given a copy to the respondents? No.
I have given soft copy.
Soft copy.
Online.
Yes.
Here is my lord issue related to paucity of fund. And order may be passed in presence of finance department because unless and until it is from them, DLSA and ASALSA may not be in a position to release that money. So far as my instruction have been received, my lord, that DLSA Dhubri, their pending amount is about 1 crore as on date, my lord. And up to 20 April
Pending council
2025.
finance, scroll Duke. After some time, let the
Further.
finance be here.
56 similar, my lord.
Similar, my lord.
Only difference, my lord, in 56, there is a judgment. But 55, my lord, there is no judgment. And this is the similar order,
In 50?
56.
56. এখনো 56 এর বাইরে।
May I please, Your Lordship? Yeah, my lord. Petitioner before Lordship for demarcation. He has approached the authority, circle officer for demarcation of the land, my lord. Subsequently, no action was taken. He also filed an appeal before the application before the deputy commissioner. But as yet, nothing has been done, my lord. While as
Yeah.
per procedure of law, my lord, within 30 days, he is to do it, my lord, circle officer.
Here, my lords, whether he has make any RTPS application or not, that I have to verify first. Right to public service.
Ah, have you made any application?
Yes, yes.
Where is
Second,
that application? Kindly point it out to her.
second thing, my instructions.
Actually, page 25, my lord.
25.
And
It is a
exactly.
handwritten application.
My lord, there is no such docket number. It is online mode, my lord. They will get a number, my lord, after filing, e-filing, my lord.
As per information, did my lord, it was not in a.
File one.
A second thing,
We
my
give
lord,
them some time to file an affidavit. In the meantime, you file that application.
Yes.
Bring it on in an additional affidavit.
and an instruction have been received from ADC, my lord, to circle officer by LR department, law assistant, my lord, that he has not have possession over the particular mutated plot of land. So
Maybe he has bought it because it is not demarcated. Other people are not allowing him to enter. No
this is
possession.
the written instruction. from the LR staff
The
has-
practical aspects.
Yes,
If there is an application for demarcation from a person who is the registered owner of that land,
My lord.
then you are not supposed to look into who is in possession. You are supposed to demarcate.
They may
How he
demarcate,
gets
my-
his possession, he is
my
heading.
possession may not be handed over till that, if
he-
any issue is there. my-
Huh?
If any issue is there regarding title or
You
something.
demarcate the land. How he gets the demarcated land is his headache, not yours.
Basically, I want information on that, my lord. This information has come right now, my.
Co-pataders have raised objections.
Sections.
Then you have to sort it there. But Mr. So-and-so on a council appearing for the petitioner also heard so-and-so on a council appearing for the respondents. The learner council appearing for the respondent has submitted, has placed a communication from, this is from whom?
It is LR staff that reported
From the LR staff.
address to
the
circle officer.
officer, Nagarbera Revenue Circle, stating that when an attempt was made for demarcation on 16/12/2024, the co-patadar had raised objections and complained, for which the demarcation could not be carried out. The council for the respondent also submits that there is no record of the petitioner having applied under the Right to Public Services, provisions of the Right to Public Services Act.
Yes, miss. 2012.
London Council for the petitioner submits that he has already made an application at a time when the said act was not in force,
Yes.
and therefore his applications should still be worked out.
Yes.
Full stop. Next para. The London Council for the respondent shall have updated instructions on the status of the application stated to have been filed by the petitioner, which are available at Annexure D and Annexure E to the writ petition. Full stop. The learned council, the petitioner shall also be at liberty to file an application under the RTPS Act for demarcation. This matter again after 3 weeks on a date to be fixed by the registry.
Helen.
The respondents were directed to file their affidavit, madam.
RTA will file affidavit. We seek some time because there is a bifurcation has happened. Assam Agriculture University has been bifurcated in two. Assam University of Fishery and Livestock, Assam University of Fishery and Assam Agriculture University are now two separate entities, my lords. That's the, there's a reason we have, it's being delayed, my lords. We'll file an affidavit. Instructions are sought for, my lord, not coming because of this issue. Because of this bifurcation issue, some instructions are not forthcoming, my lords. Some time may be granted.
His grievance is
Some cancellation, my lord. He was managing some deal and
demands from him,
my lords.
and he is not allowed to fish.
Yes, it's that has been
The
cancelled.
cancellation of the lease. And probably because of encroachment, you could not.
Yes, that is the reason. We filed a detailed representation. Without any hearing to be given to us, it was cancelled.
We'll have it sometime before the vacation.
Yes, my lords.
Because immediately after the vacation, it will be actually fishing season.
My lords. I understand. Let it.
Huh?
Let
By
it-
when? By when?
By his lordship has expressed mind, my lords. By
Mr.
just immediately
P.
before
Gogoi,
vacation.
Learned Counsel appearing for the respondents have submitted that due to bifurcation of the Assam Agricultural University, he is awaiting instructions. Stop. The Learned Counsel appearing for the petitioner has submitted that cancellation of the lease being an issue. Being an issue in the writ petition and as also the question of recovery from the petitioner, there is some urgency in the matter. Is this matter after 2 weeks on a date to be fixed by the registry, by which time?
My lord will fix a date that will persuade them to respond.
And is this matter on the 15th of December, 2025, enabling the Learned Counsel for the respondent to have his instructions and file his affidavit in the meantime. From the finance. Mr. Choliha, you are respondent number 2 hearing.
Lordship.
There is some order for payment of compensation.
Lordship.
District Legal Services say that they are running short of funds.
Lordship.
There is already an order from this court in some other matters directing payment of the
Lordship.
compensation.
Yes, Lordship.
So we make an observation.
Lordship.
Payment will be made, and
Yes,
as
Lord.
and when requisition is made by the DLSA,
Yes,
the
Lordship.
finance would take appropriate steps to have the.
Lordship.
Provided Lordship, whatever funds are required, Lordship, a proposal that
The
will be.
proposal will come from DLSA.
Submitted to us on that.
Huh?
Oh, the proposal has all, Lordship, if I can get a copy of the proposal sent, then I can ask the department to
You
expedite.
are appearing for? Who is 3? Huh? Okay.
My instructions are the government required around 1 to 2 months. Government requires 4 months.
We'll give you time till February.
The amount.
At the February lage time.
We will allow time till February for disbursal of the amount by observing that the finance will take
Lordship.
appropriate steps at the moment they receive the proposal.
Lordship.
But Mr. Anderson, Learned Counsel appearing for the petitioner also heard for the respondent number. Yes, madam, you are appearing for respondent number
Yes.
4 and 5.
4, 5.
Mr. H. Aliha, Learned Counsel appearing for the
Respondent number 2, Lordship.
2, and Mr. So-and-so appearing for the respondent number 3.
One also.
You'll appear for 1 also? Yes, one, number 1, 1 or 2. Huh? The claim here is that the petitioner had been awarded an amount of rupees 5 lakhs as compensation. Out of the said awarded amount of 5 lakhs, sorry, The said amount had not been disbursed to the petitioners on the ground of lack of fund. Full stop. Here the learned counsel for the petitioner has produced an order dated 24/11/2025 passed in WPC 6135 of 2025, comma, where this court had directed the respondent authorities to release and disburse the amount of the final compensation to the petitioner within a period of 2 months from the date of the order, full stop. The learned counsels are in consonance that a similar order would suffice the requirements of this writ petition also, full stop. Accordingly, it is directed that the respondent number 3, 4, and 5 shall take appropriate steps within a period of 2 weeks from today to submit the requisite proposal for compliance of the compensation awarded to the appropriate authority in the finance department, full stop. On receipt of such proposal, the finance department would carry out the necessary formalities and ensure release of funds for disbursal to the petitioner within a period of 6 weeks thereafter, full stop. The entire exercise is required to be concluded within a period of 12 weeks from the date of this order. We can pay the proposal in the month of May itself. Send them another copy that we have already received. This is in compliance of the orders of the court.
Lordship, subject to verification, whether or not if they are covered, Lordship, that verification.
The order is there that.
Order is there.
Five
After
lakhs.
revision order.
There's
Oh,
already
after,
an
oh, Lordship,
order.
Lordship, I have not gone through. Yes, Lordship, I have not gone through.
Given.
Yes, very, yes, Lordship.
Okay, now item 56.
56.
56 also you have to be there because here the difference is
Only here is a judgment, my lord, from the learned trial court. There is a judgment from the trial court, my lord. Thereafter, a order was passed by the DLSA, my lord, page 42.
হেৰিটা ঠিকে একে থাকিব এপিয়াৰেঞ্চ বিলাক একে থাকিব ফাংচন সেপিয়াৰিং পেজ 40
42, my lord. Award.
page 42 is what? Huh?
Sorry, wrong.
Next read is the order.
Sorry, my lord.
26.
Award of
Page 76.
The grievance in this writ petition is that although an order was passed by the District Legal Services Authority, Dhubri, on 21/2/2025, victim compensation registration number 18 of 2024, entitling the petitioners to be paid an
5
amount
lakhs.
of rupees.
He had 10 lakhs, my lord. Because, my lord, here two deceased is involved, my lord. Two deceased persons are involved in this case, my lord. So, my lord, 10 lakhs, my lord.
How 10 lakhs?
Page 77. Considering all the circumstances of the matter as well, taking into account the provision of so and so, are entitled.
Just a minute. Okay. Entitling the petitioners to be paid paid the following amounts. You take from page 77.
Yes.
Page 77, 1, 2, and 18. The entitlement of the petitioners to the aforesaid amount is not in dispute. The learned counsel for the petitioner has also placed reliance on an order dated 24/11/2025 passed WPC 6036 of 2025, whereby the respondents were required to release and disburse the compensation amount as per the order referred to therein. So the learned counsel are in consonance that a similar direction would suffice the cause raised in this writ petition also. Accordingly, the respondents are directed to release and disburse the compensation amount
5 lakhs, 10 lakhs
as reflected in the order dated 21/2/2025 to the petitioner and other entitled persons mentioned in the order itself within a period of 3 months from today. Full stop. The respondent number 3, 4, and 5 shall complete any requisite formalities within a period of 2 weeks from today, and the respondent number 2 shall take appropriate steps for sanction, etc. of the amount within a period of 4 weeks thereafter. Read petition disposed of. We have given you a time frame when you have to work. Then the money comes to the bank, then you catch. What?
My lord, will furnish the certificate copy before the.
From today. From today, everybody is present.
My
They
lord,
will do what is required. You want to punish, you punish.
my lord. Obliged.
Number 40.
Look, probably it has become infructuous. A provision of a policy of 2014 is under challenge of the railways. Right now, my lord, we have no contract with the petitioner. The central government, if they can clarify whether that policy still subsists or it has not been modified, then we may have a case.
Conspicuously absent.
But
The central government is conspicuously absent. Good. Of 2015.
15 men.
The present writ petitioner, heard Mr. B. Gogoi Learned Counsel appearing for the petitioner. The present writ petition had been instituted on a grievance against the clause number 27.9 of a circular dated 6 of 2014. Insofar as the same relates for reweighment of goods. Praying for other consequential relief. Although none appears for the respondents on call, an affidavit is found on record. It is filed on behalf of the which is filed by the Senior Divisional Commercial Manager, Railway Nandi. The learned counsel for the petitioner has submitted that petitioner is not in contact with the councils as of date, and in all probability the matter has become infructuous. Full stop. Accordingly, since the matter is of 2015, the petitioner has not shown interest in pursuing the matter, this writ petition is closed for non-prosecution. Petitioner would be at liberty to revive the petition if any cause of action survives. Yes,
I'm for respondent, Lordship. I'm for respondent.
therefore respondent. What should we do? Allow the writ petition? Should we allow the writ petition? Make some prayer. Tell us what you would want us to do. This writ petition was instituted in the year 2019, praying for directions to the respondent authorities to hand over vacant position of type 3 quarter number 324 in the Hengrabari Health Complex to the petitioner. and initiate appropriate steps to evict the respondent number 3 from the said quarter. Notices were issued on 10/6/2009, full stop. Today on call, none appears for the petitioner, full stop. Ms. So-and-so appears on behalf of the respondents. So although no affidavit has been filed in the matter, keeping in view the nature of the grievance raised and the non-appearance on behalf of the petitioner, full stop, it appears that the petitioner is not interested in pursuing his cause in the present form, full stop. Accordingly, this petition is closed for non-prosecution.
Wait, is it Lordship? Lordship, these two matters has become infructuous, Lordship.
Both matters.
Yes, Lord.
Two and four.
Has been submitted on behalf of the learned. Your name?
A.N. Hussain. My name is not your Lordship. I'm appearing on behalf.
Yes, you are appearing for Ms.
B.
B. Gogoi. Learned counsel appearing on behalf of Ms. B. Gogoi, who appears for the petitioners, has submitted that she is under instructions that the present matter has become infractuous, full stop. Mr.
Mk Das, Lordship.
Mk Das, learned counsel appearing for the
Two and four.
respondents, has made a similar submission, full stop. In view of the above, this writ petition is closed as it requires no further adjudication. Being infractuous. We do not wait for you to say the name. We actually try to take a gulp because we are speaking all the time. Let's do it at once.
This is a contempt proceeding, my lord. Almost 3.5 years. 3 years, 3 months has been passed, my lord. Order was passed on 35/2/2022. Lordship may see at page 11.
Page 11.
Page 11. 11 and 12. 45 days has been granted and very small amount, my lord. 4,84,685.
Page 11, you said, sir. Yes.
PHA has a standing counsel also.
It's a contempt petition. Would a
I know.
standing counsel will not help?
No, I know that, but notice was issued, my lord, then
No AD card from respondent number 2 is the
who is the present chief engineer, my lord.
AD card not received back. Why don't you have your council file a postal track report? They can file a postal track report showing that the item has been delivered. You have taken steps by registered AD, is it not?
Actually, like we have been engaged recently, my lord, because of
No, I'm saying from here, on 26/8, notice was issued to the respondent number 2 with registered AD. As of today, the office note says no AD card returned.
we will track the postal receipt, my lord.
Track the postal receipts.
Our first steps we will take, my lord.
The office heard Mr. So-and-so and a senior counsel appearing for the by Mr. Amit so-and-so. The office note dated 24/11/2025 reflects that no AD card or unserved notice has been returned back from respondent number 2. The learned senior counsel has submitted that he would take fresh, he would instruct his assisting counsel to take fresh steps on the newly included respondent number 2 by speed post within a period of
2 days, man.
2 days from 2 days, full stop. Prayer is allowed. Fresh steps be taken on for service of notice on the respondent number 2 by speed post.
And also by hand. By hand.
Let this matter be listed again after 4 weeks with service report. That should do.
We will take justice service also, my lord, because
And senior counsel also prays for permission to take steps by Dusty mode, full stop. Granted, steps for Dusty be taken. The registry of this court in a period of 5 days from today. And yes, the assisting counsel should go through the office notes before having a senior counsel
Yes.
appearing in the matter.
Actually,
Did not.
earlier there's different council, we are the first time appearance, sir. Anyway, right, that
From
is
morning till now, he had the
yes,
time,
yes,
sir.
yes, yes, of course. Obliged, sir.
May I please, Your Lordship?
Hmm.
Services are complete, my lord.
Hmm.
Respondent number 2, we are allowed to take dusty service and we have filed the affidavit. Of,
My lord,
Have you served copy
Respondent number 1, 3 and 4,
on
they have already
Miss
appeared.
MD Bora?
my lord, this has been served, my lord, but we have been informed, she is the standing counsel for WMD department. My lord, she has been informed that for respondent number 3, notices to go, my lord. That there's a panel, short areas development, my lord.
Eh?
For areas, my lord. Respondent number 3, there's been informed that notices to go, there's a panel.
They do not have
My lord, they don't. Although it's part of the WMD department, notices have.
anything, she received notice for whom?
My, it was for welfare and minorities, but she's not, welfare and minorities is not a party, my lord. Short areas is for which notices to go, my lord.
Previously,
It has.
I can take steps, no problem.
Or Mr. Swensel and a counsel appearing for the petitioner, also Mr. Swensel and a counsel
we-
appearing on behalf of Miss MD Bora.
Well.
Current standing counsel WMD department, full stop. It has been submitted that although Miss Bora had received notice of the writ petition, comma, the respondent number 3 has to be served by registered AD since she does not represent them and there is no standing counsel for the said respondent, full stop. Accordingly, petitioners are allowed to take steps on the respondent number 3 by speed post within a period of 1 week from today, full stop. Place this matter again after 4 weeks on a date to be fixed by the registrar along with the service report on respondent number 3. Other respondents are
So
represented.
far as respondent number 2 is concerned, the dusty service is there. So dusty service is there.
You have taken.
We have
One is represented.
1 is represented and 4 is also represented.
Respondent number 1, 2, and 4 are represented. Have
Two
been
is
served
not
notice. Have been served notice, and respondent number 1 and 4 are represented in the court. Deeply obliged.
Please, Your Lordship.
Yes, sir.
Lordship, as per the earlier direction of the court, respondent number 2 and 3 were impleted. Your
This is after lunch session. Some more energy, some more sound. Yes.
Lordship, as per the earlier direction of the court, respondent number 2 and 3 were already impleted, Your Lordship. Lordship, we may be allowed to take step upon respondent number 2 and 3, Your Lordship.
By the order dated 17/9/2025, passed in interlocutory application number 3093 of 2025, comma. The the respondent number 2 and 3, where the address of the respondent number 2 and 3 were corrected. Full stop. Have you filed the amended cost title?
Lordship.
Huh?
Lordship.
Have you filed the amended cost title, sir?
Cost title we have not filed, Your Lordship.
Amended cost title you have not filed?
Lordship, I filed. We filed, Your Lordship.
Filed. The amended cost title has been filed on 24/10/2025. Full stop.
Okay.
This is the first order issuing notice. Notice in this case was issued on 15/11/2023. Stop. that steps for service of notice on the respondent number 2 and 3 be taken by the by the petitioners within a period through speed post within a period of 10 days from today. Registry to list this matter after 4 weeks along with the service report.
Highly obliged.
Petitioner will be at liberty to file the postal track receipt. Hello.
May I please, Your Lordship?
Yes.
So non-compliance order is 11/3/2024, Lordship. Informed to us that respondent law took charge as a DC of Solidpur, Lordship.
So
now we have to.
Is a new information. What are we required to do today? Kindly tell us.
Respondent has not filed their affidavit, also. And we have to, in the meantime, we have to get the new incumbent, Lordship. So we have to notify them initially, Lordship. So, Lordship may grant us 2 weeks time. We will.
This was the first sentence we were expecting.
We have to file replacement before that. We have to file replacement before the new incumbent, Lordship. He is Hemanto Bhuya.
We are not interested who he is, but we are interested in what you are required to do.
First, we have to file
Mr.
replacement.
Mr.
K. Kolita.
Kon Kolita. Counsel appearing for the petitioner has submitted that the earlier incumbent in the post has since demitted office. Joined as the Deputy Commissioner of
Sonitpur. Sonitpur.
Sonitpur full. Did he receive notice?
Earlier incumbent, he received.
He received notice. He has not filed any
Not
affidavit.
filed, that's it.
You are representing him.
Lordship, I'm appearing on behalf of DNAT.
Of?
I'm appearing on behalf of DNAT.
Yes. So why is he not responding to the notice?
Lordship, we haven't got a complete instruction on that. Kindly grant us.
Have you filed an wakalatnama on behalf of the respondent?
Lordship.
And it is without instruction.
Lordship.
When can he come to the court?
Lordship will file it.
Once there is an order from the court,
Lordship.
the court expects a compliance. So far, so good. Then he does not comply. We give him a notice. Then he does not respond.
Lordship, here we're actually in the last order, we are supposed to file an affidavit. We'll file an
Yes,
affidavit.
then what happened?
Kindly grant us one more week.
So this should come when the matter is taken up. Mr. Kulita therefore prays for some time to inform the new incumbent to the post regarding the earlier orders passed by this court. Stop. Mr. So-and-so appears for the respondent number 1. It is noticed that the respondent number 1 has not responded to the notice, although there is an appearance on his behalf. Full stop. Respondent number 1 shall file the response to the allegations raised in the contempt petition by the next, failing which appropriate orders may be passed. Stop. Place this matter again after 4 weeks on a date to be fixed by the registry.
Lordship, we fix it.
Why? You will not impede the new person. You will not inform the new person, and we are supposed to fix a date.
After 4 weeks, any date, Lordship.
For what?
For
what is the order complaint of? Let us.
Page 99, Lordship. Page 99.
Page 99.
Yes, Lordship. Operative part.
Please read the
Lordship,
operative
this
part.
is settled provision, Lordship. Earlier,
Please read the operative part.
paragraph 6, considering the submission advance and also peruse the order that
Operative part, sir.
accordingly, it is provided that the petitioner shall file.
Operative part, sir. Page 8. For the purpose, para 8, for the purposes of this contempt, please read that part.
The entire exercise shall be carried out within a period of 4 months from the date of receipt of a
So it will be 4 months from the date you inform him. We'll give you a date after 4 months. Should we? No. Some prayers you can give, Grant. He wastes time.
2024.
After 4 weeks on a date to be fixed by the registry, by which time the respondent number 1 shall ensure his response on record.
I'll hope.
Yes.
Lordship, may I plead? I'm the the petitioner here is the minor of Gitanjali Borua. He was the respondent number 6 in earlier writ petition case number 2361 of 2023. Lordship, now when Gitanjali Borua, she has died, but before her death, she has made a will. At page 12 of my IA, I've annexed the will. I would like to read the second part, the second paragraph, and whereas means Gitanjali Borua is the wife of Gopal Borua. So first, whereas I was married, whereas after whereas after the demise of Pratap Yadav, I got married to Gopal Borua, since deceased on 9/7/2013 at Silapathar, Malini Thana district, Dhemaji. And out of our marriage, we do not have any issue. Now, Pratap Yadav is the son of from previous
Son
marriage.
from the earlier
Now,
husband, yes.
the fourth paragraph, and whereas the demise of Gopal Borua on 11/9/2016, all the date rituals during the cremations and other funeral ceremonies were observed and performed by Nilakantha Yadav. They lived as a family life, social life. So they and at page 13, so I hereby devise and bequeath the following assets to my son Nilakantha Yadav. Now, this one, second is all compensation that will be sanctioned by the Deputy Commissioner Dibrugarh. So this is the case. And just today, my prayer is to implead me as party in respondent number 6. Since
you are who?
I am Nilakantha Yadav.
You are still a minor.
Minor, no. Yes.
You are still a minor. Are you not required to?
No, when I filed, I was minor. When I filed this petition, I think now I will be 18. But when I filed this, then I was a minor.
Padma Borua has filed it.
Yes.
Who was the legal guardian of the?
Nilakantha Yadav.
Yes, any difficulty in?
Yes, Your Lordship.
Lordship,
in including him, any difficulty?
Yes, there is difficulties because actually Nilakantha Yadav is not the son of Gitanjali
That
Borua.
we will see whether he is in the.
Now, on the basis of the will, they are claiming. But Your Lordship knows that Section 213 of Indian Succession Act, the will is not sufficient if it be not become a probate. He has to file a probate case.
Nilakantha Yadav is the son of Gitanjali.
Gitanjali Borua.
He's the blood son. Not an adopted son.
No, here, Your Lordship, here the case is that the Gopal Borua is the owner of a particular property. And that property has been acquired by National Highway. Then 3 wives comes to claim. One of them is the Gitanjali. And other one is myself, and other one is there. So that is the facts. Now Gitanjali is saying that she earlier got married with one Yadav. Then she became the wife of again the Gopal Borua. The property is Gopal Borua, Borua's property. So under such circumstances, a vague will has been executed. Until and unless that has been proved in the civil court, then this is the meaningless.
Let's understand it.
Now, Your Lordship say another documents they have annexed here. Next of kin of the Gopal Borua. So only one name is there.
Whose name?
Gitanjali Borua.
17. Page 17.
So he has not submitted any certificate to prove that he is the son of Gitanjali Borua. No certificate has been, even they can file a next of kin certificate.
Birth certificate.
Huh?
We have birth certificates.
No, they didn't enact it.
I had to take no, actually, in this case, what I felt that it was for, since Gitanjali Borua was the main, at page 16, I have given the means death certificate of Gopal Borua, where it is clearly written, name of the disease is late Gopal Borua. Now comes at page 16.
At least they should have filed in next of kin certificate or the birth certificate. There is no birth certificate, nothing is there.
At page 15, my lord, at name of disease is Gitanjali Borua, name of husband / wife is late Gopal Borua.
True.
It is clearly written.
That is
So I am the wife of Gopal Borua, and I have a son.
I was the wife. Now
Yes.
that wife is in better circumstances.
Lordship, one more.
The issue is not whether Gitanjali is the wife or not.
Yes,
The
that
issue
has-
is whether Nilakanto is the son.
He is
of-
the son of Gitanjali Borua.
He is the
Show
son.
me from
No,
somewhere.
And Lordship.
Are we understanding each other?
Yes, I'm understanding, Lordship. Lordship, just I want to say one more fact that Renu Rajkumari, she left Gopal Borua prior, I think, 10.
That is not.
Now she has again married CF Style also. Okay, if Lordship gives me some time, I will give
Doctor,
the
is it that logic series coming in here? You have that, you don't have that, therefore you are that. He does not have the certificate.
He doesn't
He
have-
does not fall in that logic part. He agrees you are not in the logic part.
So, Lordship, give me kindly a certain type. I will file another affidavit.
Yes.
And the way he has managed 3 wives who are now in court, he will actually become a bone. He has been made a bone by all the 3.
Only about the strength of the will they are claiming.
Give me some time.
Unless you show something that
Yes.
you have the authority to represent the estate of Gitanjali Borua.
Yes.
Gitanjali, is it Gitanjali Borua?
Lordship, give me some
What
time.
does the will say?
The will say different things here.
The will says
At page
that
13.
he is giving you everything
Yes.
as a
Son.
as a beneficiary.
Beneficiary.
Did not.
Yes.
Does not say that
Will has also been to
the
proof.
will says that Nilakanta Yadav was born to her.
Yes, says, but it has to be proved
Something.
by filing proof.
Give me some for the purposes of deciding the right. We'll have to go to the writ. For the writ to survive, we must first allow the substitution. You get us something that he is the son.
Okay. Okay.
Some official document.
Give me some time, Lord.
Heard Mr. So and so. You are Mr.
Dr. DJ Decca.
Heard Dr. DJ Decca, Learned Counsel appearing for the petitioner. Also heard Mr. So and so, Learned Counsel appearing for the respondent number.
Respondent number, here I am the read petitioner. I am the read petitioner. And respondent number 1 in his case.
In
the
In the
IA.
IA, respondent
In the IA,
number-
respondent
opposite
number.
party number 1.
Lordship,
What is
I
it being
am
called?
respondent number 5. Lordship.
Respondent number
Private
5.
respondent also. He was the deputy commissioner then when the compensation was disbursed. Half the compensation was disbursed to the mother. It was not done by the person concerned, Lordship, Biswajit Pegu, who was the deputy commissioner then.
No,
But by
I'm just recording the present,
Lordship,
sir.
Lordship.
We'll come to the meetings.
What I
That is on merit.
is that I filed an affidavit today
In this I.
in the main case, Lordship.
In the we are only on the
Okay.
IA.
We are only IA.
In the orders column, we'll concentrate on the IA today. Mr. Bhagavati for the respondent number opposite party number 5. Mr. Dotto appearing for respondent number 7. P. Bodley for respondent number 8, full stop. The learned counsel appearing for the applicant has prayed for an accommodation to produce before this court any relevant document which would establish that applicant is
The son of
the
Gitanjali. Guru.
son of the deceased
Respondent number 6.
Gitanjali Borua. Full stop. How much time you need?
1 week.
List the matter after 10 days on a date to be fixed by the registry, allowing the petitioner to file, applicant to file requisite affidavit.
Obliged, Lordship.
Yes.
Lordship, we have filed Okalama on behalf of sole respondent, Lordship.
When?
Last week, Lordship.
Last week. What is the instruction?
Instruction received that Kala has already forwarded the matter to the arbitrator, Lordship. It is under process for hearing, Lordship. I have talked with the arbitrator, office of the arbitrator.
So recording submission of learned senior counsel matter. Recording submission, if counsel submission can be recorded, then it can be, if the matter has already been referred. So that was the direction of the order actually. If it has been already referred, then nothing remains actually. Malad,
Where is the order? Where is the order?
The relevant portion is in page 18, Lordship.
18.
Yes, Lordship.
He submitted that petitioner will be advised to approach the Kala.
Yes, Lordship, and accordingly on, that is in the immediately next page, Lordship, we have submitted the application before.
If
Kala.
any party is aggrieved, they can approach the Kala. Petitioner would be at liberal.
On 11th of April, we submitted the application before Kala, Lordship. That is in page 19.
No, where is the direction?
No, that is at last
Competent authority is directed to make the reference to the arbitrator.
within 15 days, Lordship.
Have you done that?
Yes.
It has been referred to the
Refer to the
arbitrator.
arbitrator.
Yes, Lordship, that is what I'm.
You can close it.
Yes, Lordship, recording submission of learned counsel, then it can be.
Should we do it on your verbal?
Lordship, I have talked with the office of the arbitrator, Lordship.
You are sure it has gone?
Lordship. They received it, Lordship.
Okay. This contempt petition had been instituted alleging non-compliance of the order dated 992024 passed in WPC number 4399 of 2024, whereby the following was required to be done. Page 18, paragraph 3. Full stop. Mr. So-and-so and a counsel appearing for the petitioner has submitted that the petitioner had approached the competent authority raising grievances of inadequacy of the compensation. Full stop. Was alleged, although it was alleged in the contempt petition that the competent authority has not taken appropriate steps for forwarding the matter for making a reference to the arbitrator, today, Mr. S. Dr. Learned counsel appearing for the sole respondent has submitted that he is under instructions that by an order dated 24/10/2025 and by a communication dated 24/10/2025, the matter has been referred to the arbitrator cum secretary of the government of Assam, Revenue and DM Department, Dispur. Full stop. On such instructions, the learned counsel for the petitioner submits that the forwarding of the application to the arbitrator, the order is substantially complied with. Full stop. In view of the submissions made, this contempt case is closed on substantial compliance of the orders passed in the writ petition. A copy of the communication dated 24/10/2025 will be kept on record and marked as Annexure X. Just give.
I'll provide it.
Give us a copy.
What shall
God
we-
bless you.
Yes.
May I please, your Lord?
Yes.
Lordship, as per office note dated 24/11/2025, no ID card and no answer notice is written, but we have tracked the consignment, Lordship. But consignment stated that this notice was delivered to the contaminers, Lordship.
Where is it?
But we have not submitted, but we have note down. It was delivered on 21/10/2025. Container number 1 and container number 2, 24/10/2025.
Who is container number 1?
Preeti Lekha Deka, ACS District Commissioner comes here
Come chairman.
for District of Land Advisory Committee to Bilasipa.
Korpeta.
Bilasipa, Lordship.
Korpeta.
No Bilasipa. Lordship, I am submitting one more thing, Lordship. Some document wrongly, I think, kept in this file, which was not related in this case, but it was related contempt number 521, Lordship.
You.
I have seen in morning.
Rogo. Contempt case password. এক বস্তু আমি সোমোৱাই দিলে গম পাইছে নে ইখনত হাহাকাৰ লাগিব এই যে 521 এনে সো বেলেগ হলে বস্তু ৰিটেক কৰাই পেলাই ঘৰত একো নকৰে এইটো পইণ্টত কৰাই পেলাই ঠিক কৰাই দিব
We have also informed in early morning to the court master, they wrongly kept in.
that only she can take an information.
Yes, Lord.
Directions have to come from some other side.
Yes.
The office note dated 24/11/2025 states that neither ID card nor unserved notice has returned back from respondent number 1 to respondent number 3. And the counsel for the petitioner has submitted that on a tracking of the postal consignment, it appears that the notices were delivered. Full
It
stop.
delivered to container number 1 and 2.
1 and 2.
But 3, Lordship, he is not accepted.
3 and respondent number 3 did not accept the
Notice, Lordship.
consignment, full stop. The petitioner is given the liberty to file an additional, to file an affidavit bringing on record the postal track record within a period of 10 days from today, list the matter at 10 days along with the affidavit of the
Yes, Lord.
to be filed by the petitioner.
Obliged, Lordship.
Yes.
My lord, may I submit one thing, His account is freeze, my lord. I have a small submission, my lord. The account was freezed on the basis of a letter received from Mumbai Police. What I have learned from my learned friend, he is in deep trouble with regard to money. Without considering the fact if the account can be opened, subject to he giving one bond or something, so that if anything happens subsequently, if the police comes up, the amount is secured.
You had passed on order earlier.
My lord, we have no objection.
What is the amount?
Your Honor, what has happened in the account?
What is the amount involved?
Your Honor, till now it is not clear how much amount is there because my husband's all pension amount is there. So
what is the bond?
My lord, we are
what
also not
amount?
aware about the amount, my lord.
Huh?
I'm also not aware, my lord, what is the amount? Or whatever the amount may be, my lord, 2021 रुपये the pension है, बहुत पैसा होगा. I think lot of money will be there. I'm not, my lord, we need to take instructions about the.
No, that one part we can work out.
My lord.
I think in one of the cases we have given an order.
Yes, my lord.
Where the petitioner will furnish a bond of the amount involved. You will be allowed to operate the account. Can be a bond or it can be a bank guarantee, either which ways. Subject to the satisfaction of the bank authority. Be allowed to operate the bank. If anything is found recoverable from you, you will undertake to. Will that do?
yes, Your Honor.
Will that do?
Yes.
Then you have to tell us, someone has to tell us the amount.
I'm taking instruction.
Huh? What is the amount which the bank, Mumbai Police, where is that letter from Mumbai?
My lord.
Police?
Your Honor, the word from the petitioner is that she has no access to the account. Because what has happened,
We are not on that. You are perhaps not trying to follow what the court is saying. If you can tell us what is the disputed amount for which your bank has been frozen, we can ask you to give a bond of that amount. And you can utilize the rest of the money lying in the bank. You getting my point?
yes, yes.
Your account will be operable for all purposes on your furnishing a bond. Now, what is that amount? If you do not tell us, we'll have to keep this down, take up some other matter where councils are more prepared.
You know, let,
Tell us.
let the matter be taken after some time. I'll
Ah,
take
Tell us, what is the amount?
My lord,
Just
fine.
tell us what is the amount of?
My lord.
after some.
Ki hai?
Much obliged.
This is the letter, my lord.
From whom?
From Mumbai Police, my lord. Cybercrime.
Neither here nor there. Find out the amount,
My lord.
we'll pass an order.
My lord.
After. Much obliged.
Hmm.
Please, Your Worship. Well, it might have been complied with, but I'm not sure because I have asked for the order.
Honour Counsel appearing for the petitioner has submitted that the matter might have been complied with, but he is not sure.
I'm not sure, well, because I have asked for the order. Well, I have
Please,
asked for the
don't
order.
write all those. Mr. AFNU Mullah, appearing for the petitioner has submitted that he is awaiting some instructions from the petitioner regarding the compliance of the order, full stop. Please this matter after 10 days, enabling him to have appropriate instruction.
Then we have last.
Yes, sir.
Milord, yesterday I told that I will be able to finish it by half an hour, but it seemed to me that I may have to refer some evidence.
We'll try to go as far as possible. We will try to go as far as possible.
Yes, yes, definitely, definitely. Now, before going to the impugn award, Milord, I would like to refer some provisions of law. Industrial dispute law.
Industrial disputes.
Yes. Now, Your Lordship, may please come to section 2L.
Yes.
2L. Now, what is a lockout? Definition of lockout. Lockout means temporary closing of a place of employment. The closing my place of employment for a temporary period. Or the suspension of work. Or the refusal by an employer to continue to employ any number of person employed by him. Now, my lord, there are certain provisions that we have to look into. Now, straightway, Lord, now let us to come to provision section 2Q. So, for lockout is a temporary closing of a place of employment. Now, section 2Q.
Right.
Strike means a cessation of work by a body of person employed in any industry acting in combination or a concerted refusal or a refusal under common understanding of any number of persons who are or have been so employed to continue to work or to accept employment. Now, your lordship will come to provision section 23 and 24. 22, 23 and 24. What is strike and what is lockout, that has been defined. Prohibition of strikes and lockout. Now, so for section 22. No person employed in a public utility service shall go on strike in breach of contract or without a breach of contract. Number 8, without giving to the employer notice of strike as hereinafter provided within 6 weeks before striking, or B, within 14 days of giving such notice, or before expiry of the date of strike specified in such notice as aforesaid, or during pendency of any conciliation proceeding before a conciliation officer or 7 days after conclusion of such proceedings. So, if the establishment is a public utility service, there are some certain conditions of issuing, giving notice.
Thinking the word, use of the word public.
If the establishment is a public utility service, then in order to resort lockout or strike, some conditions are to be complied with. Now, what is public utility service? Let us come. What is public utility service?
When
2N. I get equals amen.
Yes, we have read that.
Pen. Public utility service means any railway service or any transport service or for the carriage of passenger or goods by air. Any service or
We have read that, Mr. Dasgupta, we find that perhaps his industry is not a public utility. That is what you are trying to say.
Yes.
His industry is not a public utility service.
So for these conditions of 22A is required.
22A not required to be fulfilled.
But 22B is applicable.
B.
22D. Not B. A, B, and C are meant for the public utility service.
A, B, C, D all meant for public utility. I think you are talking of 23.
22.
22. A, B, C, D all for public utility.
A, B, C only.
Why? It doesn't say so. Public utility is, it starts with 1. no person employed in a public utility service shall go on strike in breach of contract A, B, C, D. It does not say the public utility and both non-public utility. It does not say so.
Yes, so far during pendency of a conciliation proceeding, now,
That is provided for in 23.
now let us come to D. During pendency of the conciliation proceeding before a conciliation officer or 7 days after the conciliation officer of such proceeding. It is also for the conciliation officer. But this dependency of the conciliation proceeding is applicable to all public utility service as well as a not public utility service. Now, if it comes to no employer carrying in any public utility shall during pendency or any pendency of any conciliation proceeding before a conciliation officer or 7 days after the conclusion of such proceedings. This is applicable. I will come later on. This is applicable for all, whether it is a public utility service or non-public utility service.
Okay.
If there is a conciliation proceeding, then the person concerned shall not resort to strike or lockout during continuance of the public proceeding, conciliation proceeding. Now, that conciliation proceeding is defined under section 12 as well as, so it is not very pertinent so far this case is concerned, but for our better understanding, Millard, I just would like to refer to section 12. Just head note. Duties of a conciliation officer. Where any industrial dispute exists or is apprehended, the conciliation officer may, where the dispute relates to a public utility service. Now, conciliation officers are some officer appointed by the appropriate, they are gazetted officer appointed by the appropriate government to make conciliations with regards to an industrial dispute. Now, where any industrial dispute exists or is apprehended, the conciliation officer may, or where the dispute is relates to a public utility service and a notice under section 22 has been given, shall hold a conciliation proceeding in the prescribed manner. If there is a notice of strike or lockout, it is incumbent on the part of the conciliation officer to hold a conciliation proceeding. If it is if the establishment is a public utility service, but that is not the case with the non-public utility service. And so far 3, 4 are concerned, that is not very relevant. The gist of these 3 provisions is there. The conciliation officer shall make an effort to settle the matter. If the dispute is settled, then a settlement will be arrived at. And if the dispute is not settled, then the conciliation officer will send his report to the appropriate government, and the appropriate government will consider that report, and the appropriate government is of the opinion that it is an industrial dispute, then the appropriate government shall refer the matter to the labor court or the industrial tribunal, as the case may be, for its adjudication. So the rest portion is that. Now, section 22, 2, there is a prohibition.
Lockout.
Lockout as well as strike. No employer carrying on any public utility service shall lock out any of his workmen without giving them a notice of lockout as hereinafter provided within 6 weeks before locking out. Within 40 days of giving such notice or before the expiry of the date of lockout specified in such notice as aforesaid. during pendency of any conciliation proceeding before the conciliation officer and 7 days after the conclusion of such proceedings. So far the lockout and strikes are concerned similar provisions. Both the parties are required to give reasonable notice. Now, number 8, the notice of lockout or strike under this section shall not be necessary where there is already an existence of strike, as the case may be lockout in the public utility service, but the employer shall send his intimation to such lockout or strike as the case on the day on which it is declared to such authority as may be specified by the appropriate government, either generally or for a particular area, for a period, for a particular class of public utility service. Miller, so far. Now, subsection 4, the notice of strike referred to subsection 1 shall be given by such number of person to such person or person in such manner as may be prescribed. There is a prescribed form for the notice. Now, let me skip it off, other provisions. Now, let us have the consequence. Now, section 23, Lordship, may please come to. No workman who is employed in the industrial establishment shall go on strike in breach of contract, and no employer in any such workman shall declare lockout during the pendency of the conciliation proceeding. Just now what I have told you. Whether it is a public utility service or non-public.
That is what I was trying to understand. Are we concerned with section 22 at all? No, it is not a public utility service. So 22, I don't think.
Lord,
they look.
Then, Lord, I have to say something.
Yes.
No, no problem. No
I
problem.
will require some time to get the concept on that.
No,
22,
Lord,
23.
one thing is that what is the idea of the legislature? So far, the Industrial Dispute Act is concerned, a strike may be legal. A strike may be illegal.
Yes.
Lockout may be legal. A lockout may be illegal. When a strike will be legal and when a lockout will be illegal. A strike will be illegal if it violates any provisions of the Industrial Disputes Act.
Understood.
Similarly, lockout will be illegal if violates any provision of the Industrial Dispute Act. Now the problem is clear here. Now strike, a legal strike may be a justified strike.
Yes.
And maybe an unjustified strike.
Yes.
Similarly, a legal lockout may be a justified lockout and may be an unjustified lockout. This is a gray area. Now, how to determine whether a strike is justified or unjustified? Whether a lockout is justified or unjustified? There is no hard and fast rule. So far, their legality is concerned. Straightway, if the strike violates any provisions of the Industrial Disputes Act, it will be illegal. If it does not violate in the Industrial Disputes Act, it will be legal. It may be legal, but it may be unjustified.
True.
It may be legal, it may be justified. So far, whether it is a justified or unjustified, that depends on the facts and circumstances of this case. And it is, so far the judgments of the Supreme Court is concerned, it is the discretion of the industrial adjudicator. There is no such hard and fast rule. That is my...
We are not having any dispute on what we are being told now. The only small thing I am trying to understand is section 22, the relevance of section 22 to the present case. when it is not a public utility service. If 22 does not have a relevance as of now, if it is for reference to understand how to apply 23, then it's a different chapter. The intent of the legislature in 22, they have said this. Therefore, 23 should also be read like this. That part we will take. But 22 as such, ipso facto will not be applicable to the present case because it is not a public utility service.
Yes.
And that notice part,
23
the notice or during the pendency of the board proceedings before the board, that is provided for in 23. So 22 we need not discuss. We'll discuss 23.
24.
If in the present case it violates any provision of 23, it is illegal. Either the strike or the lockout. If it violates 23, it becomes illegal. Although we may try to justify it. Whether the justification will stand or not is another chapter. But it will become illegal. If it does not violate 23, it may yet be legal and still be unjustified or justified. So we'll concentrate on 23. Why do we refer to 22 at all?
All right.
That is my only, that is what I was trying to understand.
All right, no problem.
Does 22 have any effect in the present case?
Now let us come to section 24. Illegal strikes and lockouts. A strike or lockout shall be illegal if it contravenes or declare in contravention of the section 22 or section 23. Section 22 is meant for the public utility service, and section 23 is for others. That has been clarified, as you also just now pointed out.
So 22 we don't need to go into 23.
But that has been clarified by section 24. What your lordship said, that has been clarified by section 24. Number 2, or it is continued contravention of an order made under subsection 3 of section 10 or section 10A. Section 10, when a reference is made, the appropriate government may exercise their power under section 4A to prohibit lockout or strike.
Yes, we've seen that. 10A we have seen. Yes. 10 we have seen. 10.3.
10.4A. Section 10.4A.
10.4A, yes.
That's the power of the appropriate government. So,
if it is referred to arbitration and notification has been issued, government may prohibit the continuance of a strike or a lockout. Yes.
That prohibition can be. Similarly for 10A is also. Yes. Okay. Now, where the strike, now subsection 2, where a strike or lockout in pursuance of an industrial dispute has already commenced and in existence at the time of the reference of the dispute to a board, labor court, national tribunal, continuance of such strike shall not be deemed to be illegal. The continuance of such strike or lockout shall not be deemed to be illegal, provided that such strike or lockout not at its commencement contravention of the provisions of this continuance thereof is prohibited under subsection 3 of section 3. That is defined. Now subsection 3, a lockout declared in consequence of an illegal strike. That is, this section has some relevance. So for our case is concerned.
Yes.
A lockout declared in consequence of an illegal strike or a strike declared in consequence of an illegal lockout shall not be deemed to be illegal. So, if a strike is declared in consequence of an illegal lockout, then the strike shall not be deemed to be illegal. Similarly, if a lockout is declared in consequence of an illegal strike, then that lockout will not be declared as illegal. Now, here in our case, my lord, strike has not been declared illegal. It may be unjustified according to the learned presiding
But
officer.
it is not illegal.
That is not illegal. So lockout will not be illegal.
That was not the reference. That was not the reference also. Nobody went into that question.
You will get some time. No problem. Yeah. After conclusion by argument, definitely you will get some time there. And this is the usual practice.
So, your next contention is that neither the strike nor the lockout were illegal.
Yes.
They are not declared illegal by any forum.
They are not declared. Not declared. They have not.
That was never the issue.
That is not the issue.
Legality or otherwise, yes.
So only thing is that whether the lockout is justified or not.
That is the only issue.
What lockout was illegal, that is not the case. Whether the lockout was justified or not. Now, I have gone through the award. It appears to me that learned presiding officer was of the view, yes, you have some grievances. But while resolving that grievances, you should have taken recourse of the conciliatory methods as prescribed by the Act itself. Without taking resort to that method, you should not have resort lockout. Similarly, so far the lockout is concerned, the presiding officer was of this view that you should have taken some conciliatory method to resolve these issues. But you have not taken, you have not made any endeavor whatsoever, neither on the part of the union, it is a finding of the presiding officer, neither on the part of the union, nor on the part of the management, that they have taken any result. So they have apportioned the blame of resorting lockout and resorting strike. And apportioning that thing, the award was passed that parties concerned will be entitled to 50% wages. That is the finding. And now I have, yes, it is the one point that I have not challenged that whether the strike was not justified. That portion I should have challenged, but fact is that we have not challenged, no problem. So far that finding is concerned that the strike is not justified, I have to abide by it, Lord. Now, this is the short area of our case, my lord. Now, before going to the materials on record, what I would like to place, but there were two lockouts. First lockout was from 9/10/2007 to 25/7/2008.
Then 2008.
The first lockout. And second lockout is from 7/12/2010 to 8/3/2012.
Yes.
So far the second lockout is concerned, it is before your lordship now. And so far the first lockout is concerned, my reference was made and we lost this case. First reference is concerned. Now we are for the second reference. Now, our basis of our case is that our wages are settled through some settlement. The settlement, tenure of settlement was expired in the year 2007 or something like that. I will place it. We submitted our charter of demand to revise our scale of pay. That was not done for 2 years or 3 years. Bonus payable to us was not paid for 2 years. Whereas the bonus was paid to the officers in the same establishment. Not only that, bonus was paid to the other establishment at Calcutta or Hyderabad at the rate of 20%. But so far the Guwahati establishment is concerned, no bonus was paid. So the workers, and bonus is a statutory right. It is not an ex gratia. After 1965, payment of bonus act came in force and bonus has become a statutory right. Now, so far the first lockout is concerned, I will place before your lordship full evidence. So far the first lockout is concerned, in that lockout, some untoward incident occurred. 16 or 17 workers were placed under suspension. All these workmen were dismissed. The union placed their demand to reinstate them or to do the suspension order. Basically, these were the grievances as it appears from the materials on record of the union. As the management did not take any steps, either through the conciliatory way or by mutual discussion, the workmen expresses their grievances by resorting some trade union activities, some slogan, some sit-in strike, etc. and etc. And ultimately, the management resorted to lockout. And this lockout continued for a period of 8 months or 10 months.
10 to 7, October to July.
December, no, 1 year, 6 months. 7/12/2010.
7/2 or 7/12? 7/12.
7/12/2010 to 8/3/2012.
10 year, 2 years. One year, 2 months. 1 year, 2 months.
1 year, 2 months. Now, again, I would like to trouble your lordship to go through the definition of lockout. UL. Lockout. Lockout means the temporary closing. Very definition, temporary closing. Closing of a place of employment. So whether
1 year, 3 months can
This
be
is
said to be
temporary
a
closing.
temporary period. Okay.
now I will place some judgment. Initially, a lockout, resorting a lockout may be legal. But due to elapse of time, it become unjustified. Initially, resorting a lockout may be justified, not illegal or illegal, but due to elapse of time, it become unjustified.
So delay may make it unjustified.
Yes,
Not delay, prolonged.
prolong. That will give.
Yes.
So, after going through the award, what seems to me that the learned presiding officer was influenced by two factors. One is neither party took the measures of conciliatory measures. Neither the union, according to him, neither the union nor the management. And secondly, what he had felt that initial year lockout may be illegal, justified, but subsequently it become unjustified.
That we could not read from the order. From where can we find that? What you have now said, that initially it may be justified, but later on it becomes unjustified.
Yes,
From
there is a
which
line.
portion?
There is a line.
From which portion can we find it? Madam, pani di bole koko. From where can we find that?
I'll place it, Milord.
Okay.
I'll place it. Yes, your lordship is correct. Not categorically so far this case is concerned here stated. He made some observations.
Yes, that part also.
He made some observations. Your lordship is absolutely correct that he had not categorically made any statement in this regard, but he made an observation on the basis of the earlier Supreme Court judgment.
Okay.
Now, so far the evidence is concerned, and learned presiding officer has taken into account of 2 or 3 cases. One is constitutional bench judgment, syndicate banks case. That is the main case probably. And first one is statesman's case. That is the judgment of Vishnu Iyer, apportionment of blame, wherein it is stated that there is no flexible rule in this regard. Statesman case was also considered. Probably statesman case also considered. Yes. Paragraph 6, the statesmen limited and their workmen. This case was considered. Here, at paragraph 16, here the learned presiding officer made an observation where the strike is unjustified and lockout is justified. Workmen, paragraph 16 of this award, page 168. While dealing with, I will have to refer this judgment, of course. Where the strike is
Yes.
Where the strike is unjustified and lockout is justified, the workman would not be entitled any wages. And where the strike is justified and the lockout is unjustified, the workman would be entitled to entire wages for the period of strike and lockout. It also held, so far it is his analysis, it was also held the strike is unjustified and is followed by a lockout which become unjustified. Become unjustified, a case of apportionment arises. So if a strike is unjustified, resorting of lockout would be a justified, but it may become unjustified. Though exactly he has not stated so.
Perhaps this
It was also
lockout
held.
becoming it was that in that case the lockout becoming unjustified depended on the fact that the workers wanted to work but the management refused. Management did not allow them to work. Therefore, the moment the workers gave that assurance that we want to work and the management does not look into it.
Yes.
From that moment on, it becomes unjustified.
Yes, 100% correct. But while
in our present case,
while taking this decision, while arriving at this decision, the Supreme Court referred another judgment.
Okay.
That is of the judgment of 1963. AIR 1963 SC, page 258. Huh? 258? No? Yes, 528. That decision was taken into account. That is Justice Gajendra Gatkar judgment. Yes, your Lordship is correct. That worker wanted to work, but they were employer had not allowed them. So it became justified. It became unjustified. And the Supreme Court referred another judgment, that is Compton gives or what page? 63. No, India Marine Service. While dealing with this case, in that case, I will refer it. In that case, is now Statesman case as well as Syndicate Banks case and this AIR 1963 528 case has some bearing so far our case.
yes, sir.
No, let me, this of the 1963 case.
What we are trying to see is there a reason? What we are trying to find out is whether there was any reason for the labor court to hold that the lockout was unjustified.
Yes.
I want to restrict to that.
Yes, that is the only case.
The reason to hold that it was unjustified. I'm doubtful whether I can go into the details of that reason or not. But if we find that there was no reason or it has not been brought down to in his observations, then without a reason, how can he hold the lockout to be unjustified? If it cannot be called unjustified, then the apportionment goes.
Yes.
That is what I was trying to find out.
Yes, sir, 100% correct. Line of approach is 100% correct. One thing what your Lordship is thinking that whether the learned presiding officer assigned any reason, assigned any reason to the effect that lockout is unjustified.
Yes, and whether that reason has got a connection with the answer given.
So, one thing that I can clarify, my lord, that so far the span of lockout is concerned, undoubtedly this is unjustified.
The span we will take into consideration. If you can show
Though,
us,
though it has not been specifically stated so.
if you can show us any judgment which
Yes,
will
yes.
require us to look into that.
Yes, yes, this is the judgment and
Yes.
there are other judgment also.
Which should I read?
Para 8 probably, and not very much.
8 is strict.
But let us read. This is the bonus issue. It is arising out of a bonus issue. One, Mr. Bose was charge sheeted and he was also disciplinary actions was taken for his cause and strike were resorted. And then the lockout was resorted in consequence of this draft, and this lockout was a prolonged lockout. So, paragraph 8. Coming to the question of the lockout, it is abundantly clear that the lockout was ordered by the company because of a sudden strike. No doubt, a token one launched by the workmen, it would appear that the strike was only to be partial and notice of it was given to the previous day in order to appreciate the background of the strike and the lockout. It is desirable to set out certain facts. By an agreement dated 23/11/1956, the management had agreed to pay 37 days' wages to its factory employees for the year 1955-56 as bonus. At that point of time, the bonus was not a statutory right. As bonus. It was also agreed at that time that the bonus was not to be a condition of service. On 10/9/58, the respondent union made a demand for 7 days bonus over and above the usual bonus of 37 days. In reply to this, the company stated in its letter dated 11/10/1958 that it does not agree to the demand that the bonus is payable to a condition of service. That although no bonus is payable, the company as a gesture of goodwill have offered to pay the workmen 15 days consolidated wages as bonus and express the hope that its offer would be accepted. On 39/10/1958, the company again wrote to the union pointing out that the workmen had resorted to go-slow tactics, which is adversely affected their business, which was of the repairing ships, and then observed, we should also strongly suggest that the management and the union jointly approach the labor directorate at once on the following issues: whether the workmen are justified in stopping the overtime as and when they like. Number 2, bonus. In consideration of this, we may even agree to pay the workmen certain sum of money, as may be recommended by the conciliation officer, on advance account pending the adjudication by the tribunal of the issue of bonus. It should, however, be clearly understood that if the tribunal decides against the payment of bonus or allows the bonus less than the amount advanced to them, the entire advance money or the difference will be recovered from these wages. The workmen by installments as may be directed by the tribunal. This suggestion was preemptively rejected by the respondent union by its letter dated 15/10/1958, the relevant portion of which is as follows. We would simply ask where had your good sense of tripartite conference before which you have adopted. Now we think as a measure of delaying tactics. We know better what to do when we will be asked attend tripartite. On 16th and
Mr.
19th.
Dasgupta, maybe just interrupt because of the
Sorry,
time
sorry,
factor.
sorry.
If we come to paragraph 9, perhaps the entire issue will be culled out with all these details being taken care of. Para 9,
Yes.
it seems to us that the attitude of the company was a reasonable one. Then it says, but the object of the strike being to circumvent settlement. In our opinion, while the strike was unjustifiable at the the lockout was ordered on 13/11/15. I'm reading in the middle. It seems to us, however, that though the lockout was justified in the commencement, its continuance for 53 days was unreasonable. This is what you're trying to point out.
There are other cases also, Miller.
Why does it say 53 days?
Now, this case was referred in the statesman case. And this analogy was drawn by referring the judgment. So, আর কি আছে judgment দেখি? For the timing, Lord, again, I am referring statesman's case. While drawing this conclusion, the statement case,
Yes.
Today I shall conclude by referring these three judgments. Now, statement judgment your lordship has gone through, and as your lordship has pointed out, it seems to me your lordship has gone through where the workmen wanted to work, but the management had not allowed to work, and so the court was of the view, though the lockout was initially legal, but subsequently by your act it became lockout is initially justified. Subsequently by your act it became unjustified. So in order to draw this conclusion, they have taken recourse of this case, my lord, that is reported in 1963. Now, and one of the reasons for referring this judgment of statesman because that there is no such hard and fast rule when this lockout will be unjustified or justified. It depends upon the subjective or objective satisfaction of the industrial adjudicators. Now, first, Justice Krishna's judgment, paragraph 17.
Only for 2-3 minutes, I'll take some leave.
No, I don't mind, huh? Paragraph 17. If the strike is illegal, wage during the period will ordinarily be negative unless considerate circumstances constrain a different course. Because there is a judgment of Krishna here, some words will be a bit restricted. Likewise, if the lockout is illegal, full wage for the closure period shall have to be forked out I have no forked out, I can understand. Fork means I,
Forked out is when there is hay which we use to feed the cows, hay, kher.
acha.
There they use forks to pull out the hay from the stack. So when it says, if the lockout is illegal, full wages for the closure period shall have to be forked out. It has to be brought out from the stack, from the coffers. It has to be drawn out from the coffers of the management. If it does not give it, it has to be taken out by force. Tera ungli. You use the fork to bring it out.
Acha. That is what he is. Have to be forked out. If one may use that expression, but in between lies a gray area of duality law. Strictly speaking, the whole field is left to the judicious discretion of the tribunal.
Yes. Now, here, that is what I was trying to find out. This there will be a difference in the discretion, judicious discretion.
Judicious discretion.
Moment we talk of judicious discretion,
Definitely.
we talk of the reason.
Reason. Whether it is a reasonable person, whether it may be a reason given by a reasonable person.
The first thing I would see is whether there is a reason, whether the reason connects to the order, to the reason connects to the
impugned order. But
to the
reason has
conclusion,
any nexus.
the conclusion. Whether it is connectable to the conclusion.
Reason has any nexus with the conclusion
And
drawn
yes.
by the tribunal.
Because I had the occasion to go through a few judgments which say that if there is a reason and it has a connection, writ court need not go into the whether it was a good reason or not so good reason. We will not look into that. There was a discretion.
The court may differ with the conclusion. But if it's found that yes, he while drawing this conclusion, while giving this conclusion, he has assigned some reason. And that reason is a reason given by a reasonable person.
That has a connection to the conclusion.
There
Yes.
might have some, I may not agree with this
Then
thing,
there is
but
neither
that is
any
different thing.
procedural flaw, nor is there any perversity. Why should you interfere?
That is.
Someone has to decide it.
So what appears, subject to rectification by your lordship, what appears to me that the presiding officer was influenced by the factors that neither the management nor the workmen has taken any steps to resolve their existing issues through a conciliatory methods.
So he used apportionment of blame to come to this conclusion.
Yes.
He did not apportion the blame because of the conclusion.
Yes.
He first had the blame
of both the parties.
He first noticed the blame of both the parties, then he came to a conclusion.
Yes. That
it
is
should have
my
been the other way around. He should have come to a conclusion that it is unjustified, then you give the blame to both the parties. He
That
cannot
can
put
be.
the cart before the horse. It is what I was having a feeling when I was trying to find out. One thing, we're running short of time, so today, so I would just like to have a look at the portion where I am not very convinced. This, that order of the tribunal, where is it? Order of the tribunal. Yes, I should.
পরে দেখো এটা আজকে টাইম শর্ট আছে
Order to put a say.
Page
Yes.
one.
Can you come down to this page?
Page.
Page 167.
167. Paragraph 15.
Paragraph 15, I am at paragraph 14.
Yes.
From the bottom, if you count 7 lines, one.
Okay, that has been taken from the judgment of the Supreme Court.
No.
Strike is open. There is a syndicate bench
What
judgment.
I'm trying to come is this. 4th line from the bottom. The starts with
second,
illegal.
third.
The first word is illegal.
If the strike or lockout is found contrary to the standing order, it is not correct. Standing order has nothing to do.
Service rule, then the same.
The standing order or standing
Now
service
this-
rule,
now
then
the next
that
line
is
disturbs
not correct.
The next line is disturbing me.
That is not correct
Yes.
because strike will be illegal if it is contrary to the Industrial Disputes Act, not with the standing order, not with the service rule.
Now
It is his own notion, Millard.
Another-
That the pardon does not get discharged simply by proving lockout to be justified. At the same time, it also incumbent on the part of the management to prove that the lockout imposed by the management was a last refuse. Yes, that is.
From where he has found this?
Yes,
That it is the last resort?
Yes, there is a judgment.
Once the management says it is justified, that last resort part
Yes,
I'm not
yes,
finding
yes,
anywhere.
yes, there is a judgment.
There is a
Yes,
judgment.
there's a
You would
judgment,
like to go
and that judgment he has not, though he has referred, actually he was a, though this judgment he has referred, but he has not pointed out. That is the judgment I'm telling your lordship.
From here, we have a feeling that he is trying to say, you may be justified, but it is not the last resort, and therefore we find it unjustified.
Probably
From where
not,
he's getting these
not
ideas?
happily worded. That your lordship will find that is syndicate bank's case. I will
Syndicate,
point
na?
it out.
Again read it.
We have to read it the syndicate bank's case. This is he has borrowed this word from that case without referring this thing. That has created a problem. By the said workman union, paragraph what's 15, no?
Just above 15.
Yes, yes. I don't know whether he has referred the syndicate bench. He should have referred. It's a constitutional bench judgment. There is a specific word, the strike and roll should be sparingly used.
That is another issue, but it should be the last resort.
Yes, it should be a last resort.
That part I'm not being.
No, I will forgive
Try
you.
to go through that the judgments which were given to me.
I will give it.
Reference to this case.
There are some other cases also.
It has to be a last resort.
Yes, last resort. Yes, there is a well settled principle. Well settled principle is that you must take the recourses available to you. And if you cannot settle your dispute by taking all available resources, you may go for a strike or lockout. So it should be considered as a last resort. Probably he could not explain it properly, but it was in his mind. Your lordship fix a date, tomorrow or day after tomorrow. Tomorrow I have a case. I don't think that will be taken up. Day after tomorrow.
Early.
কালি অসুবিধা আছে নেকি? কালি নালাগে নেকি? কালি মোৰ এটা কেছ প্ৰিপেয়াৰ কৰিব লগা আছে। যদিও the case will be adjourned. Till then I have to prepare it.
Luck was favoring you tomorrow. Perhaps tomorrow we could have touched your case. Perhaps tomorrow we can continue from our side. I am prepared.
Your lordship is free.
Perhaps.
Then I shall take a chance. Well, I have a fixed case. That is with him. And they have given adjournment prayer. I don't know what will be, because it's a long pending case. I have to prepare this case today.
Here, in this case, you would not require any much preparation.
No. I have to ascertain the judge. I have to go through my notebooks.
We'll keep it for tomorrow.
All right, let me try. Let me try, but I
We will try.
well, for this
Is
case,
it convenient, sir.
Wow.
Keep it at the option, বাইদেউ। এনেকুৱা ক্লিপ আছে
নাই?
আছে চাওকচোন। নালাগে হ'ব। ফাইলটো লগত থাকিলে মই থৈ দিছো। পিছত অনাই পেলাই লগাই দিব এটা ক্লিপ এটা এই ওপৰৰ এইকেইখনত দেই ছেপাৰেটলি আছে। Time and paucity let this matter be listed again tomorrow to allow Senate Council for the respondents to continue his arguments.
Not much.
Very Mr. K. Kolita. Yes, for the petitioner. That bank matter, yes. We'll try tomorrow, sir. Yes, did you find anything?
Yes.
What?
Your Honor, the amount right now in my account is 3,11,32 rupees. Confirmed by me also, confirmed by the bank also.
Yes, you are for the bank.
Yes, Your Honor.
And what is the disputed amount?
Your Honor, the total disputed amount is.
Okay, what we will do is, you are keeping it on hold. He will give you a bond for 3,32,000 whatever. Subject to the satisfaction of the bank authorities. And you will be allowed to operate that account, and any adverse orders requiring you to pay, the bank will be in a position to enforce the bond, if so required in law. Yes, heard Mr. Swensul and council paying for the file to the action time. But this is only an interim order. We have yet to come to the decision of it. Yes. Heard Mr. You are Mr.
G. Kaushik.
G. Kaushik, Landed Council appearing for the petition. Also heard Mr.
Prasanto Gogoi.
Santo Gogoi, Landed Council appearing for the respondent State Bank. Full stop. It is submitted by the Landed Council for the petitioner that due to freezing of this account, the petitioner is suffering since she is not able to operate the account or to either to deposit or to withdraw any money from it.
I cannot access the account.
And she
No
does not
access.
have any access to the accounts as such. Full stop. The Landed Council for the bank has submitted that it was on a request made by the police authorities of Mumbai that the bank account has been frozen so that recoveries, if any, can be made from the said account in case fraudulent transactions are proved for the petitioner in proceedings by the Mumbai police. Full stop.
Yes, sir.
The Landed Council for the petitioner has submitted that the petitioner is agreeable to execute a bond for the total deposit available in the bank account.
Yes, sir.
In case the bank agrees to allow operation of the usual operation of the bank account. Full stop. The petitioner is also ready to to give an undertaking to the effect that any amount legally and lawfully recoverable from the account shall be met by the petitioner if such orders are brought to her notice. Full stop. Although this writ petition, other pleadings complete, have you filed your affidavit? You have not filed your affidavit.
No, Your Honor.
The council appearing for the respondent bank has paid for some time to file their response to the writ petition. Full stop. It is seen that the freezing of the bank account has would put the petitioner to jeopardy, and on her assurance to execute the bond as well as the undertaking. Full stop. This court directs that in the interim during pendency of this writ petition, the petitioner would be allowed to operate her bank account bearing account number. Please give the account number in so-and-so bank by furnishing a bond and undertaking to the bank authorities to their satisfaction of meeting up any lawful and legal liability imposed upon the account of the petitioner with regard to the alleged fraudulent transactions as reported by the police authorities of Mumbai. Full stop. It is made clear that the operation of the bank account has been allowed only on the assurance of the petitioner to execute the bond and the undertaking. Full stop. This order will not affect the merits of the case, which will be decided at the time when the writ petition is taken up for disposal. Full stop. This matter again after 4 weeks on a date to be fixed by the registry, by which time the respondent bank shall ensure filing of its affidavit in opposition.
Much obliged.
Obliges.
Thank you. পাঠ কাইলৈ যেতিয়া আহিব